The truth is, you're as dumb as they come.
It's the house!
Did you hear what I said?
Hello. Yeah. So apparently Google Earth is, we're going to keep, you can still do it up until June. Well, it's always going to be available to use, but they're not going to keep updating it after June of 2027. The Google Earth desktop version. They're just going to do the online version. Sucks though, because you can't move around the same. You know how we do the flybys and stuff? In Google Earth desktop, web, you can't do the same flying around, the same movements. You can still zoom in and stuff, but it doesn't allow you to kind of rotate in and stuff like that. Kind of sucks. So I guess we'll just keep the desktop version too, you know. But I might have to go learn that one. Well, how's everybody doing today? This should be the final day. I had it already scheduled for 5 days. They said 4, but they had 5 on their calendar from the beginning. They must have known that the defense attorneys would do what they were doing. You know, there's people talking about the .223 caliber bullet found on one of the roofs. What does that have to do with anything? You know, it makes it sensationalized, like, oh my God, there was a .223 caliber bullet found on a roof. Well, how long was the bullet sitting there? And then the main thing is the bullet that killed Charlie Kirk was a .30-06. So what difference does it make that there was a .223 on a roof somewhere? It doesn't mean anything. It's just sort of a thing that you go, oh, bullet, and then Kirk, oh my God, there must have been what? I mean, so a guy with a .223 caliber drops a bullet on a roof, and Kirk shot with a .30-06, and somehow they're connected. I mean, I just, you know, I'm not sure what that even means to these people. It's wild, crazy, Looney Tunes. Oh boy. Fragments. Yeah. Right. I'm just checking out Twitter. These people, they're so obsessed. They just keep playing Kurt getting shot over and over again, as if they're just like turned on by it, you know? Yeah. Yeah, I remember, and also, yeah, during the trial yesterday, they showed the photograph of the rifle. Remember how people said, "Oh, that's not real." It was perfectly described how they did it. You know, how they put it in the box, etc. What do you mean, why is there discoloration on the muzzle? Who knows? Who cares? I mean, these people ask questions that are just like, it doesn't mean anything. That's one of the things I don't like about true crime is people, you know, you see so many people, they want answers to every little tiny thing, but they never question their conspiracy theories. So you got these conspiracy theories, and then you have a rifle on the ground, and the end of the barrel is a little darker than the rest, and everybody wants an answer as if that has some meaning of some sort to the case. And it's like of whether or not Tyler did it. Who cares? I mean, it just, like right here, for example. See right here, people are looking at this, and it's a little, see how it's a little darker right there? What does that mean to anybody? Like, how does that have to do with Tyler shooting or not? It's like, man, that's when you're just desperate. You're that last little, God, we can find something. We can find something. I know there's something out there. Now, they just never question anything about them. Like their conspiracy theory nonsense that Candace puts out, they just take it face value with no proof of any kind. When they say they're receipts, they don't have receipts for anything. It's sort of like this fake receipt, you know, like, wow, this is a receipt, and then they go, okay, cool, there was a receipt, but the receipt isn't a receipt of anything. It's just sort of a comment like somebody said something. Again, the most clear-cut case I've ever seen. You know, I love how the media sort of jumps in now, and everybody's like, yes, and they don't know a damn thing. You know, they're just, they have these talking heads. Paul Morrow's always good, no matter what. But. Oh, yeah? Cool, Jim. He's currently in Daytona Beach.
Daytona Beach. It's awesome. I was swimming around in the sea like a seal this morning.
Yeah, well, you don't want to swim around like a seal too much because there's actually animals, you know, fish in the water that would eat a seal. You know what I'm saying? Yeah, I generally don't swim where I could be considered food at any point. You know what I'm saying? Do you think our own government told us the truth about JFK? Hey, moron, this isn't the same as JFK, okay? And that was so long ago. In today's day and age, there's cameras everywhere, etc., etc., etc. It has nothing to do with this case, okay? This is Tyler Robinson killed Charlie Kirk. There is no doubt. Now, what do you mean? Did I see any message about the 223? I don't know what you mean by that. Let's see. Guess what, homie? I will just unsubscribe. I don't care, dude. I don't care if you do or not. You're exactly the kind of person I don't want here. Okay? I don't want people like you. You are an embarrassment. Yeah. What does it have to do with JFK? Comparing Charlie Kirk to a government cover-up on JFK is ludicrous. Kirk was a friend of Trump. They say he was questioning Israel at the end. Who cares? What does that have to do with anything? You're an embarrassment. Let's see. I don't know what you mean by Gray, did you see any message about the 223? What do you mean by that? Okay, well, if I didn't see it already, then just type it in again. It's hard for me to go find something. You said any message, not my. Okay, was that at trial? I don't remember. I sometimes I don't hear everything. So you're saying it was on, but it was on a different roof too. Like it was on the. Like right here, right? It apparently was on this building over here is where, way over here, a bullet was found. I never heard him say that at the trial, or the hearing or anything. Well, it's too early in the morning for me. I can't read. Somebody acts like I'm gonna. You get a conspiracy theorist and you call them out on it, and then they unsubscribe, and it's supposed to hurt your feelings. It's ridiculous. I really don't care. You know. I think it's embarrassing when people act like that. Yeah, you guys. I do think that there's. Yeah, if you can send it to me, that'd be cool. I don't remember seeing it at trial, though, in the hearing. They probably have an answer for it, though. They kept asking, even the prosecution brought it up. They probably just didn't want to say in court, like, exactly what they're going to say. By the way, what difference does it make? You know what I mean? I keep trying to tell people, it's a .223 caliber. Kirk was shot with a 30-06. So it's not related. What does it have to do with anything? I mean, some other shooter that was there that day was careless and dropped a bullet on the ground. He just never got his shot off, and then, that's the part I don't understand. Yeah, maybe it was one of the early witnesses. Yeah, but even if it wasn't accounted for, too, it wouldn't matter at all either. That's what I'm trying to really get at, is, it's great that it's accounted for, too. So now it's like, okay, it's not only did they find a bullet, it was accounted for. But if it wasn't accounted for, it doesn't mean anything, right? No, in the beginning with an accent. I remember them talking about it, but sometimes I'm just having to deal with so much other crap. I miss words, Thank you, Megan Kelly. I guess I would say that, right, yeah, you need to, I know. It's like there's two things, I guess. If it was already accounted for, maybe they didn't. They maybe missed it like I did. I mean, I kind of remember them talking about it. I just didn't remember hearing. I guess we can go back and try to find that stuff. Maybe we should. Maybe we can do like a condensed. Like I could probably squeeze the trial into like some of those days into 30, like 45 minutes, because of all the objections and stuff. Or maybe we can revisit specific witnesses at some point. How about that? Yeah, I think that'd be kind of cool. Just kind of do like a recap, and we'll just go find specific witnesses, and yeah, that'd be cool. And then just play them. And then I'll edit it so it's just kind of like when they're speaking. Oh, yeah. Yeah, that's a good one. That's a good one. Let's see, where is that damn thing?
Need to quiet the conspiracy theories. The pro burgers crazy.
This is when I was
State
on the...
supports. I even brought up the pro burgers on my when I was on Court TV. Do you guys see that? I'm sure they'll get the obligatory. I can't believe you had gray on your show, Vinny.
Oh, shoot. That's not the full one. Okay, let's see. Is it this one?
Risks of trial. The Brian Enton's thing. Risk of trial. Either
Okay, this one. This is it right here.
state supports. I even brought up the pro burgers on my when I was on Court TV. Do you guys see that? I'm sure they'll get the obligatory. I can't believe you had gray on your show, Vinny. I'm never watching again.
Yeah. Let me see.
State supports.
Do
I
it
even
right
brought up the pro burgers on my when I was on Court TV. Do you guys see that? I'm sure they'll get the obligatory. I can't believe you had gray on your show, Vinny. I'm never watching again.
Alright, there you go, there you go, there you go. What panel? What are you talking about? We don't do panels in here. Yeah, if you can find that part for me, send me a link to it. Anybody can find the 223 comment. I kind of remember vaguely, you know, I do. Like, I remember them mentioning an officer, and then it just was like, I guess I wasn't focused right at that moment. That was me, Rebel Rose. That was me on the screen. Yeah.
Let's try for a ocean wave emoji to get the show started.
Wild Bill Wassman trying for an early wave in the morning. That was funny. Chris O'Connell showed up last night on the show, but Carl with a W, they always do these little battles or helping support the channel. Carl with a C is what I meant to say, not with a W. Carl with a C was on here, and he was wondering where she was. That was pretty funny. Hey, thank you, Born to Raise Hogs. All right. Well, let's try to do, I'm going to see what Google Earth is, how it works. You know, this doesn't seem very, it's not easy to use. So how do you just get to Google Earth? You know? Data layers, new sea plant. Now they have it's like a paid thing. Yeah. Oh, there it is. Explore Earth. There we go. See, when you hit the mouse, just zooms in and out. You can't do the spiral rotate. Well, actually, let's see. Does it do? Oh, there you go. So if I come in, so you have to hit the shift key to rotate. So it's pretty cool. I mean, it's got, you know, it's not bad. It just doesn't have this awesome thing on the side either. I don't think. Maybe it does. It does say that you can bring in So you can't do a roll at the same time. Like on Google Earth, you can go like this. See that? That's sweet. I mean, you can't do that on the web version. Oh, that's cool. What is that? Oh, that's a cool one. I like that. This one allows you to go like straight down on something. I like that.
It might be a good time to play the I'm never watching again video.
See, that did it. Flew there that way, though. Huh. How did it do that? How did it fly over there that way, but it didn't? Huh. I like that. That's pretty neat. We can go up and down. No border, label, places, or roads. Oh, that's kind of neat. Just a quick button for the... So let's see, how would that work? I was right. Oh, that's Google Earth. I switched right over to Google Earth. Right here. So if I'm right there and I hit the shift key and go down. It doesn't seem to want to let you get low, like if you want to get right on it. It sucks. Yeah, I'm not really liking it too much. Because it doesn't let you do... Oh, that was kind of... There you go. This pans on a pivot, so that's not too bad. I like this one, man. It's just like, you know, you can just zip around, come right in, look, move however the hell you want at an angle like this, you know. I might have to make a video on, you know, the whole thing about, like, you know, Tyler Robinson stopping, almost leaving, and then turning around. And then all the devastation that occurred after he turned around. He could have went the other way. See, right there again. Just zoom in there. Look at this. Here he comes. And he's walking on the campus. He's at the point of no return. And then he goes, I don't know. I just, crap, I'm going to do it.
Bilbo's wave.
Because right there, that one little moment in time was the time where he almost changed his mind, and he didn't. Yeah. I've been pointing that out since the beginning. I thought that's always been a pretty big deal in my mind. But it was sort of augmented yesterday when Twig said that he saw Tyler Robinson cry and said he wished he'd never done it. And so that sort of fit that moment right there. I was like, oh, look at that. That's exactly that moment. I don't think he's crying because he wished he didn't do it to Kirk. He's saying it because he knows it ruined his life. His life. He doesn't care about the Kirk part of it. Thank you, Jim. As in Jim Lawn, the fish food. Jim actually showed me a picture of him swimming. He sent one to me in Florida. He's literally wearing a seal outfit. You know, not just, he said, oh, I'm like a seal. He literally had on these little flippers and everything. And, you know, to me, that's not really that smart because that's right in the middle of the ocean where a shark actually might think of you as food. Okay? I'm just joking. He didn't send me that picture. Okay, somebody out there will believe it. Let's see. There's that still. Yeah, I thought yesterday's, the Twigs interview was pretty interesting, and then there was some new stuff on the messages. But other than that, there really kind of wasn't much, Other than, the DNA, she said that it was inconclusive. The defense wants it to be conclusively not, but it's not going to happen because there were striations that matched. You remember those times where I circled? It looked pretty clear that was the same thing. But there wasn't enough of those to make it conclusive because of the damage done to the bullet. So the defense wants it. They're going to get a witness at trial that says it conclusively doesn't match, but it'll all be absolutely destroyed because even if the prosecution says that it's actually inconclusive. Look right here. See these marks? These ones look absolutely the same, but then we can't make it out here because there's a lot of damage. So I'm not able to say, that it is a match, but I can say it's inconclusive whether it is or not. And then you go through the circumstantial evidence and talk about, okay, well, he mentions in a message the same writing that's on the bullet that was fired, the shell casing that remained. He wrote on that one. His DNA is on the shell casing of that. It's on the rifle that was shot. He left a screwdriver on the roof that he put together the rifle with. That had his DNA on it. It also has Tyler. So Tyler, I bet he took the screwdriver. That there was this guy that made a video on Twigs and all that. Probably be interesting to go watch that again. But they had this table in their house that had all kinds of electronic stuff on it. So I guarantee it, that was just a screwdriver he just grabbed off of that table that they'd all used, or both of them. So you had Twigs and Tyler Robinson's DNA on that. The towel came from the house, so obviously they probably used that. He probably just grabbed it right out of the bathroom. And there you have it. Pretty clear stuff. Let me get the audio. Okay. Court should be started already. What do you mean? Hit it in the nose? Oh, I don't know.
You do see a lot more significant. And you get that reaction to time.
What have you guys found to be the most interesting parts of the trial so far?
You know when you get hit by the instas?
Or the hearing, whatever you... To me, it's like a mini trial. You know, it's obvious. I mean,
It's hard to get back
they have
to DC, you know, after being in a place like this.
direct cross-examination, etc. Recross,
Is that part of me that's just, can't fuck off the map?
twigs. I thought mine was the surveillance footage. That's what I think was the most interesting. I like putting it all together, the pieces, and then I like looking at it, being confused, and then fixing what they screwed up on by flipping the video. Because it was a puzzle. I was like, what in the hell's going on here? I'm not even sure why that occurred to me, that they may have flipped it. It just didn't make any sense what they'd shown. And the way they presented it was absolutely idiotic. I mean, you have to pause the video after he's walking. He exits the garage, you pause the video, and then you describe with another image showing where he walked on campus with little circles showing where he went. Then you come back to the surveillance and say, now here's him returning an hour later. They don't do that. They just, so here he goes, he's leaving, and then they show these other steps, and you're like, what the hell's going on here? And I hope they have a better presentation than that.
No, but I'll put I might have to do a move from see if any
Oh, those are pretty interesting, those target practices. I wonder what they're trying to imply. Like he was getting more, he improved with his shooting. He must have scoped it in. You know, like he got the scope centered. You know, after you do some shots, you go, okay, and then you have to, there's two different things that you adjust. One's sort of like the, I'm not sure what you call it, but the panning, and the other one's the up and down thing. So you go, you know, you have to kind of minutely do it, and you do more shots, and then you can dial it in. You can actually do it on one set, really. If you can get a nice grouping, you can just adjust it based on that, and then boom, you're right in the middle, and then you can even fine-tune it after that. I have this really sweet pellet gun that I have a rifle that I've done that with. I don't have a rifle. It's a Black Cat something or other. It's pretty sweet. It's funny. It's actually an air rifle, but it actually kick to it when you shoot it, because it's a break barrel one, really powerful. I think it's over 1,000 feet per second with a. They make some sweet pellet guns now. These massive, like, huge pellets that are like, you know, could smash into a car. I mean, they're just crazy.
I didn't see him.
I don't know. What do you mean by the dad? I don't know what that means. Probably seeing twigs and the bullet stuff, but I need someone to explain that. Explain what? What do you mean by the bullet stuff? What it showed was that the bullet fragmented when it hit Charlie Kirk's. Entered Charlie Kirk, hit his bones, and it fragmented. Probably the type of bullet that was used that made it easily fragment. Maybe something, Tyler, who knows what he did to the bullet itself. And it was so damaged that they weren't able to put it back together to make a comparison that you could say this is 100% a match. They said it was inconclusive, but it didn't rule out that it was a match. It's just that they can't say that it's 100% a match. That's it. It's real simple. Oh, range day with Dad. Yeah, it doesn't really matter, right? Like, it's like, what difference does it make if it was a range day with the dad? It's him practicing. Why would he keep his dad's range? Hey, Dad, those are nice groupings. Can I keep those? Yeah. He obviously shot them himself, or he wouldn't keep them. And there's not even that great a grouping, so why would he keep his dad's? You know? That's pretty funny. Yeah. Yeah, it was extremely damaged. It fragmented all over the place, and she had to use a pliers to sort of pull it apart and try to make a match. But one part I was wondering about was they didn't have the whole metal jacket part. I'm just trying to, like, where is that? Was it in the? Did it go somewhere? Did they extract it? What does that mean? Even damages, it matches 60%. Is that what she said? Did it match 60%? Did she say that? I didn't hear her say that.
No, okay.
That'd be a pretty cool line if she said that. That means it's more likely than not a match. They just can't use the term. I don't know. That's not what she said. She said that there was a jacket on the end of it. She described it. Don't you guys remember yesterday when she showed a sample and she didn't have the... Like, there's this part at the end that the rest of the bullet goes in, and she didn't have the rest of that. Yeah, I'm not sure what the 60% that you're talking about, Joey. I didn't hear her mention soft point on there. Okay, so it was a copper, so it was jacketed. Okay. Okay, because it's soft tip, the jacket didn't. What do you mean it didn't exist? Why did she explain all that in court then? Well, here's what I don't understand. Why did Twiggs... I mean, it's kind of stupid on his part to take an image of it before burning it. Isn't the whole point of burning it so it doesn't exist? Okay, well, I wouldn't say that's 60%. There was a lot more, below it, but those ones did match, so it's like, okay. But and don't throw words out honestly in the comments as if you had a number from something. Okay, just say, yeah, it looked like there were some parts that matched. The rest was too damaged. Oh, Tyler burned it. Okay, there you go. Is that what he said? Okay. Interesting. So how come there's a picture of it? Maybe Twigs took a picture of it and sent it to some friends or something like, God, did you see this, you guys? Right. We saw that. It looked like, as Wild Bill pointed out, that like it had sort of normal damage to it, but maybe it kind of, I didn't see the full peeling thing. It looked like only partial, so I don't know if it like came in at an angle or what happened there. But I've always thought the bullet came in and it wasn't completely, you know, I don't think it had its gyroscopic stability or whatever the term is. Like it came in slightly slapping, you know, like it didn't penetrate directly with the point first. Because the hole seems bigger, like it comes in and it's kind of a big hole, and there was so much surface force that's what it seemed like. More like, you know, when you slap something or you poke something. Yeah. Yeah, that's what I was saying. I've said that 1,000 times. Yawing. That's what I think. I mean, I actually brought that up right away during the case. And I got a lot of pushback from it. Maybe it's not. Maybe it is. I don't know. That's just what it appears like. There's just so much pressure, you know, like force right away on the surface. It didn't like penetrate and then, I don't know. I think Twiggs probably, you know, had those conversations. You know, they talked more. I don't think he knew more about the shooting. No. But I don't believe that they never talked politics and never talked about Kirk. But hey, guys, we're already hitting one of those lulls right off the bat. It'd be nice to just have a nice, smooth day of reaching a goal. So if you guys like my coverage and like the other stuff that I've done on this case, or even other cases, I'd appreciate your guys' support today while we're covering the case, and you know, maybe even before the show even starts, or the hearing today. But you know, the show started. I'm tired. Jesus. Man, I was wanted to just keep sleeping. I was like laying in bed going, I'm feeling good. This feels good. I want to go to sleep. I usually don't get up until like 9 something, because I do my show at night till like 10:30 or 11 a lot of times, and then all of a sudden, you know, when you're done, I'm not really sleepy at that point. Thank you, Apathetic Kid. Apathetic Kid. Yeah, that's okay. Yeah, I don't disagree that there was a soft point, but there's a jacket still on those, right? That's what she was talking about. Flow state. You can tell those are for like the video game players. I'm in a flow, man. I'm in a flow. I don't know what a flow state is. Like how much, what you send it in, let me see. Flow state. How much are flow states worth? It doesn't say on there. I don't know what to say. Anybody know what a flow state is worth? I don't see it. You're saying court's on? I don't see it. Let me see if there's somebody else doing it. I can always just get that on there really quick.
Or private discussions by recording equipment or by those present in the courtroom. Second, the court will address the camera operator and the still photographer. If both of you could please approach the lectern.
Is he going to get mad at him?
The court's purpose in this dialogue is to ensure clarity regarding the expectations governing today's proceedings. Could you both please state your roles for today's hearing?
My role is to capture pool photography, still photos.
My role is for video in accordance with the court decorum order.
And I apologize. Would you mind putting your names on the record?
Tess Crowley.
Megan Thackeray with KSL.
Thank you. Have you both reviewed the court's standing decorum order?
Yes.
Yes.
Do you understand the requirements set forth in that order as it applies to your activities today?
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
No.
Do you anticipate any difficulty complying with the order?
No.
All right. Thank you both.
I think I was like this.
Before we begin
It's a
this
pool
morning,
camera,
the court
so
wishes
it's
to
not like
acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. Cell phones are not permitted in the courtroom unless expressly authorized. Any unauthorized possession or use of a cell phone or electronic device in the courtroom may be addressed by the court. For those individuals who have a cell phone, I invite you to join me as I silence my cell phone to ensure that the proceedings today can proceed.
Yes, everybody,
without
turn off your cell
distraction.
phones, okay? Oh, wait, that means you can't
The court
watch.
also
Forget.
expects every person in attendance will be treated with the dignity and respect to which they are entitled. Consistent with this court's standing decorum order, all spectators shall remain quiet, civil, and orderly at all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or of other visible reactions during the hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or in opposition to any person connected with this case or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, and orderly, and faithful to the rights and dignity of every person involved. All right. My understanding is the parties wish to address an issue before we get started. Is that correct?
We may.
Mr. Novak.
Thank you, Your Honor, and good morning. I passed up to the court after providing copies of it to counsel for the state and counsel for the media, a single piece of paper. Does the court have that?
I do. Thank you, Mr. Novak.
Thank you, Your Honor. So every morning, this court has a colloquy with the camera operators about their ability to comply with this court's orders. And they acknowledge that they understand the order and that they can comply with it. And the court asks them if they have any problem with it, and they state to the court that they do not have a problem with it. We also spent many, many, many hours of court time addressing which exhibits will and will not be published through the electronic media. And this exhibit, the court ordered would not be published through the electronic media, and it was. And without belaboring the point, the court can imagine our concern.
Why does it matter?
That
showing that
the media and the state who control this exhibit and the publication of this exhibit in the courtroom as per the court's orders, failed to comply with this court's orders after all of the effort that we made and the court made to make sure that the court balanced everybody's rights, including the rights that we're concerned about, which are Mr. Robinson's. No doubt the counsel for the media and counsel for the state will say that it was a very, very brief mistake, that it was corrected as soon as they realized the error, but it's done. It's out there. It's photographed.
You can't unring the bell.
I'm informed secondhand that if I want to buy this image and maybe even have it framed and put behind museum quality glass, I can do so and put it up in my office. Obviously, I'm not going to do that. But my point is, it doesn't matter how long the court's order was violated. When we live in an electronic world, it's done and it's permanent. And we just
But
want
why does it matter that the note was
be
done?
clear that we're concerned
Who cares?
that the court's orders have been violated, and they've been violated with respect to an order that was specifically designed to protect Mr. Robinson's right to a fair trial. And I don't want to belabor the point any further. I'm also not going to refer to the exhibit with any more specificity because it's not necessary.
Is there a requested remedy or potential sanction
God.
that you feel is warranted given the actions which you have outlined?
Take the
this
death
morning?
penalty off the table.
I think that we would like to think, when I say we, I mean
Yes,
Mr.
indeed.
Robinson's counsel, about that. We have, as the court knows, repeatedly asked this court, moved this court, not to have electronic broadcast of this proceeding, of any of the proceedings and specifically this proceeding. The court denied those motions and overruled our objections to the specific EMC requests. So I think it's a little premature, but I can represent to the court that we will suggest a remedy in advance of the next hearing.
Well, Mr. Novak, I appreciate that, but I would ask that if it is something that is concerning, that it be addressed immediately. So I'm not going to wait until this. I recognize and appreciate what you have described, and this was on my mind a lot last night as well.
Okay.
I don't want to sit on this, so I ask you respectfully to confer with your counsel and come up with that.
I like
because
that.
I want to address it. I agree. It is concerning, and it warrants examination and to be addressed immediately, especially as we have a little bit left of our preliminary hearing. So I want to give it the weight it is needed, and I don't disagree with you.
Then why don't we beg the court's indulgence? We don't need to empty the courtroom. We can go talk about what we think an appropriate measured sanction would be, and we can bring that suggestion back to the court in a few minutes.
All right. Well, before we do that, I want to turn to the state and to the media to address what you've addressed. And then, obviously, if there's a part two, then
Who
therefore.
cares that
Appreciate
the note was
invitation,
shown?
And I also
What
appreciate
difference
the
does it
court's
make?
desire to address the consequences, if any.
What consequences?
Thank you, Mr.
I was not
Novak.
trying
They
to
read the
delay it.
note.
I just
Who
think
cares if
it's
you see a picture of
it's
it?
It's an issue which warrants some thought. The court has said it gave it some thought. We will have a suggestion.
He doesn't like that people can read it over and
Turning
over
to
and
the
over again. And it's damning. I think the cameraman
Honor.
realized after a minute.
I think at the outset it's important to recognize that everyone's doing their best here. The court is, I know the clerks are, I think the media is, we certainly are, and the defense is. This issue came up in the context of an examination of a witness. One exhibit was published.
He's got it right
before
there.
the
That's it.
exhibit at issue was also brought onto the screen. I explained what we were going to do, and then the exhibit was brought onto the screen. I reviewed the video last night. The camera captured this for approximately 2 seconds. The camera operator, I think, acting in diligence and appropriateness, immediately panned as soon as she realized that there was a new exhibit on the screen. The court took it down, and as soon as they realized that an exhibit was on the screen, I immediately instructed my paralegal to take it down, and it was. Defense, I think everyone involved here made quick and appropriate efforts as soon as they realized a mistake had been made to remedy and mitigate that issue.
I put it on there again.
As I explained what I was what we were going to do, defense counsel did not object as that happened. And the reason I bring that up is because of the requirement for timely objections. Moreover, I do want to say this exhibit was read into the record. It was allowed to be read into the record earlier. It is also in an earlier pleading, which is the information. This portion of that exhibit, I understand, is in the information. And it is largely cumulative of Exhibit 16 and 16.1, which were previously admitted into evidence and published to the media. Finally, we are going to be dealing with a lot of publicity when it comes to media coverage, and I think that's really where the remedy is going to be addressed. I understand there may be a remedy that can be fashioned today to prevent this kind of thing going forward or going on in the future in this hearing, but I think ultimately that's where this will be addressed. Any other questions from me, Your Honor?
Well, not at this time. I will afford you the opportunity, obviously, to respond when the defense comes back. I want to weigh this and taking in consideration, and I find your representations to be accurate as to what occurred. I believe that I noticed it and asked for it to be taken down because I have a live stream on my screen for that very purpose. And the sequence, I believe I made note, and if I'm wrong, please correct me. It's been a long 4 past days, but that's the only addition that I find to the representation. And certainly, Mr. Novak, feel free to correct it if you believe the sequence was any different. I just want to make sure a clear record is being made of what happened in order for whatever happens
next. Was it only
next
2 seconds? I thought it was a little bit longer.
Appropriate and proportional to the actions that occurred.
No, and that's consistent with my memory, and I also reviewed the video, the live stream as well, in preparation for this issue today. So that's exactly what I think happened. From my perspective, examining the witness, I did not have a view of what was being published to the public and the media, and so I think the court immediately, as soon as it recognized that, brought that to the...
I just don't understand why it's such a big deal.
To the media.
It shouldn't have been hidden in the first place. Hopefully he says that.
Good morning, Your Honor.
Good morning.
Appreciate the opportunity to be here to speak on behalf of the media. I think our understanding of what happened is consistent with what both the defense and the state have said here. So I don't want to belabor that point. But here's how I understand them. There's 2 exhibits at issue. Those exhibits were used yesterday in part because the juxtaposition of those 2 exhibits might have provided some sort of benefit to the court. The first of those exhibits was asked to be published through all 3 of the court's phases. The court said it will be admitted into evidence, be shown in the courtroom, will not be shown on the cameras. That happened about 3 hours into the hearing. That all went smoothly and well. That operated exactly as it is intended to. That requires the participation of everyone, the court, the defense, the state, media, camera operator, all to do that well. Later in the day, when in the video I reviewed, this was about 5 hours into the runtime yesterday. The second exhibit that was going to be compared side by side was introduced. That also went through that 3-step process. In that case, the court said that that could be admitted into evidence, shown to the court, and then also shown on the cameras. So it was put on the courtroom cameras. At that point, there was what I think is a useful practice by the camera operator to wait a beat, because sometimes mistakes do happen, right? In that case, though, that was authorized. So the camera then panned to the screen, which is set up specifically for the camera operator to be able to capture that. Examination on that exhibit began. Then, because the examination seemed to call for that juxtaposition, without much warning for anyone involved, the previous exhibit that was intended to be juxtaposed was placed on the screen. From, I think, a observer's view who didn't know where the testimony was going without warning. The camera operator, I think quite astutely, within seconds, recognized this is a different exhibit, and recalling the court's prior order, recognized I should pan off, and did within seconds. I think at the time that was happening, the court also caught that and said, let's not do that. Now, and that was the end of it. I think the 2 seconds is about right. I don't want to minimize that. I understand the point that Mr. Novak is making. We are operating in some ways on high wire. And we are trying to place as many nets as we can, and all the parties are working together to try to do that. But in the age in which we live, one of the challenges is that sometimes when something like that is placed on a live stream, someone can screenshot it, and like Mr. Novak said, if they want to put that for sale on the internet, then they can. That's why working together to ensure that even small mistakes like that don't happen is critical. And the media has the media coalition that are given the opportunity and the benefit of being able to be here to run cameras and to take photographs have complete buy-in on that point. There are, of course, people out there watching a live stream that are not part of our coalition that we can't control, and that's why it's so important that we get these pieces right. I do want, without going too far into the evidence, to note not only that several lines of this exhibit are available publicly in the information, but that the full text, every word, of that exhibit is contained in a search warrant, in this case, that was initially filed on September 17th. This is in the 4th District, but in a different court. Was held for 6 months, as search warrants often are, but then on March 16th, March 17th, was released in full. On page 7 of that
That's what I'm saying. This guy's nailing it. This guy's, it's already out there.
I don't want to suggest
Why does it matter that the picture...
Anybody gets the right to say, well, I think it's public. The court has said don't show it in the screen, but since I think it is, we'll just come back later on and tell the court it's not a big deal because it's already public. That's not how it works. If we say we think it's in the public, the court says, I understand that, but I'm going to make an order. That order should be adhered to. But I do, for purposes of prejudice, for potential remedy, for the court's concern and the court's sleepless nights, I do want the court to know that as well. And members of our coalition have pointed out to me as we've talked about this, while we take this very seriously, it is true in this case that the full text of that, not the image of the exhibit itself, but the full text is already in the public sphere, has been reported on, and is out there. I only want to reinforce, to close, the recognition
that was a good argument.
The media, our coalition, I, as an attorney for that coalition, have an obligation to make sure that mistakes don't get made. And in this case, even though I believe that the camera operator didn't act in violation of the court's decorum order, didn't do something that was forbidden by that there was an order that said, don't publish this exhibit. And because it flashed on the screen when the camera operator was filming that screen, that did happen. The media is fully bought in. I, as one of the attorneys and the other attorneys for the media coalition, are fully bought in on a goal to make sure that this kind of thing doesn't happen. Of course, I understand Mr. Novak and the defense's need to make a record and make an objection, and I also recognize and appreciate and understand the court's role in trying to make sure it imposes whatever sort of direction, caution, sanction, response that it believes is needed to make sure that its orders are recognized and adhered to.
They need to do a different process
we'll understand that,
where there's somebody signaling,
comply with whatever it is.
okay, you can film that.
Thank you. Anything further before we break? Mr. Novak?
We don't need a break.
Okay. Well,
The court wants a break.
I want to review this. I'm sure there's a stream out there. I want to look at it again in order to appreciate the full effect and exposure. I remember it, but given the nature of this and trying to weigh the constitutional rights of all parties, I want to be thorough and look at it exactly so as we move forward.
I thought it was longer than 2
as I
seconds.
evaluate what's being requested by the parties, that I am at the level of knowledge and because for what it is, it was on screen. I want to look at it, how long, what exactly was on screen, and in order to be at the point of saying, okay, I fully understand. I mean, I was here, I saw it, I noticed it on the screen, but again, I want to take that extra 2 minutes to review that.
I am not suggesting that we rush through this at all. I just wanted the court to understand that our request for the remedy and the sanction, we are prepared to share that with the court, but we can certainly wait until the court has had an opportunity to review whatever the court thinks it needs.
Why don't you
to
tell him
review.
now so he can visualize it while
Permanence
he's reviewing?
of this violation of the court order is a different issue from how long it took to correct the violation. It's a permanent consequence.
Yeah, I mean, even if it's 1
In other
second,
words,
the image
that
is
image is
still
out there
I have
forever
it.
and ever in violation of the court's order.
Right.
no matter what actions the court, the state, and the media took to remedy it, because that's the technological world we live in. So that's my response, if I may, to the arguments. But we can hold our suggestion until the court's ready for it.
All right. If the parties feel it'd be helpful to confer while the court is reviewing it, you may, just so that if you choose to, I encourage it. If you don't, I respect that. A court's going to take about 5 minutes. Again, I just want to review it to be brought up to full speed and just.
I mean, I understand
have
the
it
defense
freshly
is.
in my mind.
I'm going to make one more point, if I may.
Of course, they're going to
This
do
is not
this.
the first time that this has happened. We had earlier proceedings in this case where the cameras depicted images inside the courtroom that the court had prohibited, and the court imposed certain consequences on the media as a result of that. And so that's just something to keep in mind, in my opinion. Thank you.
All right, before the court takes a 5-minute recess and to review this, does any party need the benefit of the record based off the
Erika Kirk's
dialogue
attorney,
between
come
the
on,
ends?
running up there.
All right, not seeing anybody respond. The
guess not.
court's in recess. We'll come back at 9:45. Court is in a brief recess.
Yeah, that's crazy. Huh? How's the other one going? Is it going yet? Okay, yeah, I'm going to switch over to this one. That's better. Yeah, this one's like a full... Yeah, these are like pool cameras, so that, there's just one feed out there. Why not? I mean, I understand what it wasn't supposed to be on the screen. I don't understand why the ruling was made that couldn't be on the screen. What they didn't want is like, okay, here's what he said, and look at that. He even wrote it himself. And there's an image out there that it's like, wow, look at this. But the thing is they already had the text of what was on there. So I really don't understand why it's a huge issue, It's crazy. Everybody, that's all over. Anybody who played the show yesterday has it on their video. It's not like, of course, people are going to show the image now. It's out there, just like the defense attorney said. I mean, it's the truth. Once there's an image out there, it's out there. I don't know how to find that one little clip really quick. I was thinking of looking at that from yesterday, but I could try here in a second. Yeah, maybe that one's better. Yeah. All right. Thank you. Back to the massive lulls.
Good to see some of the conspiracy creators slowly come to reality.
Who are those people? Come on, there's no way any of them are coming around. And what they're doing is they made all their money already, so now they can just go, okay, yeah. And then now they can be the expert of the, now that they got the whole crowd, they can be the expert of reality now. These guys, they're just clowns, these people. Unbelievable. It's embarrassing. But their viewers won't think that. Who are some of the ones that are coming around? Well, actually, I don't want to know. Don't type them in. Oh, jeez. See, like yesterday's show it didn't make any ad revenue. Doesn't that suck? Jeez. It's marked as that. So stupid. God, unreal. I have to have it request a review. That just blows. See that right there? Right there, that little no ad earning other notices. You know, it's so stupid. It's just the way it is, you know. So that's why I need your guys' support. Okay. So like that whole show that I did yesterday, there's 0 ad revenue on it. So if you guys could please help support the channel, because today will be exactly the same. If you like what I'm doing, it's really frustrating for me. Don't know what else to tell you. Who was on the stand? Was it the lady? It was near Twigs time, right? Was it before Twigs or after? Gotta be. Oh, there it is. Wow, that was a miracle. Just popped it up right there. Let me see.
So as it's, and what is your request?
To comply with court's order.
All right, so 16.3 and Exhibit 24 may be published side by side only to the courtroom.
Here, I'm going to pause this and then I'll speed it up and we'll catch right up. But here's what this is what I got. It didn't have, that's me putting it back on the screen again. I don't know when they did that. That's when I showed it again. Mine's a lot longer. It's got to be right around this time because they show the burned note.
For the judge where the writing is.
Yep.
The burnt paper.
And describe what you're
burn after reading.
General location on the image.
Yeah. So the part that I'm pointing out is the paper that you can still see the lines in them. And
I wonder why Twigs took a picture. Must be right after this because I'm not talking about it. Picture of it.
As well as some.
Isn't that what they said earlier?
As well to the edge, the left edge of that piece of paper.
All right.
Maybe send it to somebody.
Have you also observed
Here it comes.
The image of a note that was recovered from last Twig's phone?
Yes.
And I'd like to show you side by side Exhibit 24.
Okay. Yeah, it was only about 2 seconds, so that's not bad.
And there on the left, you see.
Go back to it. Yeah, and I was like, go back to it, you idiot cameraman. But he actually knew what he was doing. Okay, or she, I guess. But
Then on the left, we see Exhibit 24. Do you see that?
Idiot.
Yes, I do.
And on the right, you see, excuse me.
I was the idiot there, okay? She panned off like she should have. All right.
On the right is.
I'm going to go back. This guy's so stupid.
I'd like to show you side by side Exhibit 24.
Oh, wow, it came up on again. You gotta be kidding me. Wait, or is that me? No, that was me. I went back and I opened up a different session and then copied it while it was still playing.
And there on the left, you see exhibit, well, let's go. There on the left, we see exhibit 24. Do you see that?
Yes, I do.
And on the right, you see, excuse me.
Okay, so that's it.
On the right is 24. On the left, it's 16.
Let me stop.
What the heck? What? Who's filming somebody's head? Wow, that's it's weird. The camera was allowed to drift. But yeah, guys, let's get the some support for the channel up here. No ad revenue, etc. We're only at 1/3 of a goal, so it'd be nice to, you know. Started off good, and it just died. All right, I'll be back in a minute. Thanks, Allie Cake. Guess you're the only one that listened. It's just amazing. No, I think he might. She apathetic it. Probably thinks that maybe they'll do a settle somewhere, you know, do a plea deal. But the plea deal is not going to be where he just gets to plead guilty and go off to prison. It's going to be one where he has to sit up there and answer questions, go through a whole thing, in my opinion. Yeah, I was going to say it's going to be a lot longer than 5 minutes. It never takes 5 minutes. I don't remember the part below the main part that's been in the public, but that wasn't on the screen. It's an apple. It's not a pastry. It's an apple. Hey, thanks, Stevie Lynn. Yeah, you haven't missed anything. The defense team brought up the fact that the note was on the screen, and they want a remedy for it. And now the judge is back reviewing how it went down, and then they're going to come back and argue what the remedy for putting the image of Tyler Robinson's note, basically a confession note, on the screen, even though the text of that has already been out in the public. How was that for a quick breakdown? And that was the argument by the media was, well, the text is already out there, but yes, it wasn't supposed to be shown on the screen. When the camera person noticed it was on the screen, they seemed to realize that that wasn't supposed to be shown and quickly panned off of it. The defense attorney says it doesn't matter how short it was. It's on the screen for the world to see. We could even frame it if we wanted to. We could get a copy of it, put it on our wall, etc. Yeah. So anyways, after this, he's going to come back after reviewing it. Then Novak's going to tell them what the remedy should be for accidentally showing the confession note, for lack of a better term, on the screen, and then they'll argue about it, and then the judge will rule. To me, it should just be, we'll just try to make it in the future where, that can't happen by, having some communications going on, whatever it is. But there should be no sort of like benefit. It's so undamaging. It's like it's already, everybody knows that he wrote the note and what was on it. So I don't really understand. I don't even know why it was kept from the public. I guess it's sort of like, okay, here's the text of what he said, but it doesn't have the same, like, but we already knew it, right? Like, we knew that the text came from a note that he wrote. So I guess it's just the fact that you can see it gives more weight to it. I don't know. Hey, thanks, Stevie Lynn. Thanks for the quick catch up, but we all knew what, yeah, right. And we all knew that he wrote the note, That's the thing. We know that he wrote the note. And so I guess it's just sort of like, oh, now you can see a handwritten note that he wrote. I don't understand why the judge made that ruling. I think he erred in doing that. It's just, to me, it's an exhibit. It should be seen. There's no reason it can't be seen other than the defense thinks it makes their client look worse that we actually see the note instead of just saying he wrote a note and here's what he said. It's too prejudiced, you guys. Yeah, that's when you commit crimes, evidence makes you look that way. It looks that way, okay? That's a sound effect, by the way. Right. The reason the defense didn't want it out there is for what Cindy just said. They wanted their people to keep claiming, well, where's the note? Where's the note? And now they can't do that anymore because there it is. It's right there. Well, then that means you haven't tried a Honeycrisp, Timothy Cecil. The good fresh ones. Right, it has a greater impact, but there's nothing wrong with that. What difference does it make? It's still the same words. We know that he wrote it. You see it. They don't like that it has a greater impact. But I don't understand, like, why it couldn't be shown. That's kind of what the whole point is. I mean, it'll be shown at trial. So I guess what it is like, okay, for the probable cause, maybe it's like, okay, it's too much to show that because it has a great impact, and we just need 51% probableness. I wonder if they come back. Well, we'd like the death penalty off the table. God, give me a break. Yeah. You can't unring the bell is basically what this argument is. But the bell shouldn't have been something that needed to be rung or could have been rung. You know, this should have been put out there, in my opinion. Yes, he did decide that it shouldn't be, but it never should have been kept from the court. It's just part of an exhibit, like you're talking about. Okay, here's the burnt note. Let me ask you this. How come we can see the burned note? And then we can hear what was on the note that was burned, but we can't see the note side by side after he took the photo, you know, because apparently Twiggs must have taken a photograph of the note. Or hell, maybe it was, I don't know how that, he did describe that somewhere, but I missed it. As he was explaining it, I remember I didn't want to pause the trial and keep going. Does anybody remember what he said about that? And the note kept going, by the way. You know, like there's stuff below it. I have the, you know, when we look at it right here, you know, right down, I wish we could have lived in, you know. I think there was more on the screen, too. Thank you, Wisconsin Cat Mom.
You did great. Smiley face emoji.
Yeah. So you got, I don't know. I just saw, the judges made some really stupid opinions in my case. I think Novak makes him nervous because Novak has, every attorney that Robinson has is like this high-end attorney that the state gave them intentionally so that he'd have the best coverage in a case that he has almost no shot, you know. So they want to make sure of that. So these attorneys are high-end, so he's over there nervous about them, appeals and so forth, so he keeps caving into little things just to make it seem like, I don't know, I'm not digging how he is currently, you know. I thought he was a little, you know, he's made some cool rulings prior, disagreeing with the defense, etc., like, you know, allowing cameras and so forth. But he's sort of turning into a little bit like he's weak towards the defense. Giving them all, I mean, I guess it makes sense to give them all, you know, the deference that they, you know, whatever the hell you want to refer to that as, but it's just, I don't know. I guess we'll see. Let's see how he does right here. Yeah, I think he's been unbiased. I'm just saying I think he's gone over the directed towards the defense is what I'm saying. You know, and that's generally when people say he's unbiased. You know, a lot of his stuff is for the defense for reasons that don't make sense to normal-minded people. I guess that's the thing. He seems to be giving the defense, like yesterday, it was like when I did this weird psychic moment because I knew what he was going to do. They were trying to say, well, how many pages could it be? And they said, okay, well, let's do 34 or 35 pages. And then he goes, okay, for this other part, how about half of that? So 17. But I immediately say he's going to say 18 because he's going to make sure that the defense gets that extra page because they already wanted more on the other part. Instead of 30, they wanted 40, so they settled at 35. Okay, so the prosecution wanted 30 pages for a brief. The defense wanted 40, so the judge said, I'll do 35. And then he said, okay, for some other part of it, let's do half of that, so that would be, half of 35 would be, he goes, I'll go with 17. But I thought he's going to say 18 because that's what the defense would want. That's the higher of the two numbers, 17 or 18. You can either go 18, which is high, or 17, which is low of 35, but he said 17. And then all of a sudden the judge said, the defense attorney said, well, we would have rather had 18, and then the judge goes, okay, 18. And that's exactly what I originally thought he would do, because the defense would have wanted 18. He first said 17 and then caved to the defense. Not that it's a big deal. I'm just showing you that's his mindset. You know what I'm saying? Yeah, this is going to be way longer than 5 minutes. Like I said. If they say 5 minutes, say it's going to be 35. It's like you just throw 30 extra minutes on it. Unless it's a break. Usually those are...
I'm tired of it.
Hit that like button 10, 20, hit that like button 40, 45, 50, hit that like button 60. It's the easiest damn thing to do in the world. Hit that like button. Use your nose, use your toes, whatever blows, but just hit that like button. Take out your finger and press the damn thing. If you don't have a finger, use your nose, use your toes, whatever blows. All right. Yes, you guys, hit that like button for me. Thank you very much. And if you have the ability to help support the channel with channel memberships or super chats, they're greatly appreciated. It allows me to keep going here on the channel when there's absolutely zero ad revenue on the live streams for 8 hours. And at the end of the month, we also donate thousands of dollars. And like yesterday, we donated $500 to the Gary Sinise Foundation. So there you go. Fun fact, found you the day Charlie died. Well, I'm sorry, that's the day that you found me. And I've been hooked ever since. I love your intelligence and sarcasm. Thank you for being amazing. Well, thank you. It's such a nice thing to say there. Thank you. And look at that, we got Carrie Lou Me. Thank you for gifting those 5 memberships to people, and welcome to the new 5 members. And thank you, CJ. Appreciate it. Very kind. Thank you, guys. Yeah, so they're all saying he looks like he's 6 feet tall, but see how I spread it out the way it's supposed to be?
Different clothing.
Or like he looks 6'1". And the reason it looks that way because see that line right there? They made it high up on the screen. It looks like he's just so tall. I get what they're...
And he also is...
And then they had it really thin because they filmed it at 45-degree angle.
Walking with
I stretched it out and made it look the way it's supposed to look.
Gait or limp in this video.
With the gait or what?
A limp.
Right. So we can go back like this. And just put them about right there. And then we can open up my... Let's see, it's the camera angle. Yeah, see, look at that right there. That's the line that they're talking about. He looks like a tiny person if you look at that. I mean, see, like if you look at it like this now, and that's the line, the reason he looked tall is because it looked like it was the roof, and they had it cut off right there. See, look at, watch. See that? See over there? There's the line, and the camera is cut off like that. I can make it look like that. It looked like this. You know? I always make stupid faces in here, so it's like... let me see if I go all the way over to there when I'm standing over by here. But look at my head's way above the line there, right? And it's like this, see? I think, let me see how they have it. No, it's more like this, just like that. So that's how they have it right there. You see that? That's the camera angle looks just like this. So yeah, wow, man, look at it. I'm 7'8" there. That's crazy. And it's also because it was narrow, you know. Yeah, that's right, Stevie. That's right. Oh, it's back in session? Okay.
Matters and balancing
All right,
costs.
hold on. Let me
Back
get
in session, noting the presence of counsel and all parties, and where
God,
we
it
left
froze
off as
again.
the court took
Weird.
a recess to review the video. And I appreciate the patience of the parties as well as everyone in attendance when it comes to constitutional matters and balancing
sped it up
constitutional rights and
25%.
transparency.
Take about a minute.
This court will take the necessary time to make sure it's given the weight it deserves, and it is deserving
All right,
of every
thanks,
moment
Wildman.
that has been spent. Mr. Novak, turning to you. And perhaps before you begin, let me go ahead and make a record of what I noted that is at issue. And after I put this on the record, certainly if either side wishes to be heard about the court's understanding, I welcome your comments. Exhibit 24 was displayed on the monitor visible to the media camera. Exhibit 16 was displayed on all monitors and appeared on the live stream for approximately 3.5 seconds. The camera operator redirected camera before any party called attention to the display of Exhibit 16. Approximately 16 seconds later, the court observed the image and stated, "Let me stop you, Mr. McBride. I'm not sure. Is this being broadcast?" Mr. McBride responded, "Let's take that down." The full text of Exhibit 16 had previously been made public through a search warrant that was publicly available on or before April 2026. The portion displayed on the monitors did not contain the full note and consisted of approximately 78 words. Approximately 15 of those words were included in the information filed on September 16th, 2026. In addition, the full note was read into the record during the preliminary hearing. The court previously ordered that Exhibit 16 be admitted into evidence and permitted its display within the courtroom, but prohibited its publication through the camera used for the live stream. And that concludes the findings of the court as it relates to this issue. Do the parties wish to be heard before we go into what you're requesting about the record on what occurred?
Your Honor, your recitation is accurate. My earlier comments were based on my memory of reviewing this last night. In the recess, I reviewed the feed again, and what you have said today is accurate.
Thank you. Mr. Novak, any?
No, Your Honor, I don't take issue with the court's factual summary.
All right. Turning to you, Mr. Novak.
Thank you, Your Honor. We're going to renew our request to exclude all electronic media coverage from all future proceedings. That was our motion docketed at number 305, and that included video cameras, still photography, and audio. This is the second time that the court's orders concerning the scope of electronic media coverage have been violated. I'm a baseball fan, and I just don't think the court needs to wait for the third strike. 2 strikes is enough. If I may, the alternative remedy, which we think is not wholly adequate, which is why we think it's an alternative and a less desirable alternative, is for this court to both reverse its prior order authorizing electronic media coverage of today's hearing, which we had previously filed an objection to after the court, I would say, preliminarily granted the request for today. That was sort of the chain of events. And that the court proactively preclude electronic media coverage at the last day of the preliminary hearing, which will be September 1st. Now, I understand that there has not yet been a request for electronic media coverage for September 1st, but there is no doubt that there will be, just as this court previously observed that it wasn't prepared to preclude electronic media coverage at the preliminary hearing because there had not been any requests. There were requests, and those that were timely were all granted. The court denied one request because it was not timely for one particular day. So I guess the way it would be is any request for electronic media coverage of September 1st will be denied because that's the appropriate sanction for what happened yesterday. The fact that the content of the exhibit was previously summarized by the state in certain documents which became public because the state didn't take any actions to seal them beyond the 6-month period. The fact that the contents of the exhibit were read in open court is not the issue. The issue is when the court issues an order, everybody must comply with it, and there are reasons for the order. And the reasons, as this court stated, are to protect Mr. Robinson's right to a fair trial. So no doubt that the court balanced those prior ways in which the content of this exhibit had already been disclosed when the court decided that there would not be electronic media coverage. That's a fact that we have all known of that exhibit. That's a fact that we've all been aware of as we've gone along. So to summarize, and then I will stop because I know we still have a witness here, and of course the court needs to hear from the state and counsel for the media, I suspect, is we would like the court to
Are you out there, Joey?
its order denying motion 305.
There's no more
For the balance of all of the proceedings in this matter, or as an alternative.
There isn't
the court
more
prohibit
Twiggs
any further
interview
electronic
than what
media
was
coverage
shown.
of the
Okay?
preliminary
He just
hearing,
edited
which
out
includes September 1st.
the redactions.
Thank you,
Mr. Novak.
Thank you very much.
Turning to the state and then to the media.
Yes, Your Honor, as to the remedy.
Okay, thanks.
We've heard of instances where the media has been able to delay publication of the recordings of the proceedings. We've heard of instances where that has been a short delay of like 30 seconds. I've talked to the media attorney about this, and they do not have the capability to do that right now. My suggestion would be for future proceedings to order the media to look into that capability, and that would be a remedy that perhaps could be used in the future. I think that would be a satisfactory remedy to avoid this type of thing in the future. As to the other remedies requested, we have one witness. The final witness, well, the defense has one witness. That witness is a ATF DNA forensic biologist, and I assume that the exhibits that will be admitted through her will be of that nature. We've already, in fact, admitted the report that she is going to be testifying to. The reports, I should say, that's exhibits 30 and I believe 34. And so I don't think we have, and those have already been published, I don't think we have the same risks or, I'll just say risks with her testimony as we do with some of this other evidence that has already been admitted.
Thank you. To the media.
What was it you suggested, Carrie?
In a proceeding like this, the parties in the court and the media are working together to learn and to refine their processes. I hear Mr. Novak's remarks about challenges that we've run into in the past. I recall, it hasn't been that long ago, a time when the camera was placed in a location in the courtroom that was causing challenges. The court moved it. When there were challenges with aspects of the court's ruling, the court reiterated those, and those processes improved. We are getting better at this. Media is on board and recognizes the court's obligation and its significant efforts to balance the interests here. In light of the court's ruling, including its recognition that the media operator in this case beat almost all of us to the punch, right? And saw what was happening on the screen and moved away as quickly as they could. We believe that the procedures that the court currently has in place, even if they don't, every moment of every hearing deliver the result that we are intending to deliver. Those processes are working. I don't believe that a further adjustment, much less a sanction, much less a revisitation of something that says let's keep every photographer, every camera out of this courtroom for every proceeding. In light of the court's well-reasoned and exhaustive rulings after long briefing on all of this, the court is currently balancing these interests correctly, and we therefore ask the court to allow the parties to recognize that the time we're dedicating this morning.
I don't know,
represents a
Joey.
reiteration of the importance
He
of
wouldn't
these
have any more than anybody
media and
else.
the parties all recognize
There's
that.
no more
Continue
interview
to
that was
endeavor at all
released.
times to do all that we can to ensure that those are adhered to and let the parties go forward under the current procedures without further order or sanction by the court.
Oh, I don't mind a delay in the live feed. How do we know if it's live or not? I mean, what difference does it make?
The court issues its ruling.
No, thank you for the opportunity.
Thank you. And just updating my notes.
I mean, if everybody's delayed,
I'm intending to issue
a
this
minute,
ruling
like
right now.
30 seconds, who cares?
Making
right?
sure that
I
I'm
mean,
capturing all the points made in the argument right now.
like this isn't even really live. He said that probably 5, 6, 7, 8, 10 seconds ago. Yeah, that's a good way to do it, Carrie. I like that one. But hey, Joey said that like there's more information in those interviews with Twiggs, and it's like Vinny's playing it. And it's the same interview. He can't have more information than anybody else. That's all they played, and that's all he's using. Okay, there isn't another interview out there that somehow has more that he got. Okay. The only time that has ever been played is right there in court. So, if you heard about the gay relationship thing, that was me talking about it, that maybe that's what they were talking about. in that one sentence where he, yeah. Anyways. He might have been, I said it on my show, and then maybe he said, ooh, maybe he's referring to that. Yeah, no, but they wouldn't, he just is playing what was shown in court, just like everybody else. And I just played it last night on my show, and it's not there, so. He types about like I do.
Arrival, it was a dynamic and active scene that I believe was originally being treated that there was an active shooter on campus. So there was a large, rapid response of law enforcement who were actively trying to clear, secure, and ensure that the campus was safe, if that answers the question.
The entire campus?
Yes, correct.
Okay. And what types of officers were there clearing the campus?
Originally, there would have been probably local units who would have responded, but subsequently specialty teams would have been deployed to do a more methodical search of the campus and what we would call a clearing of the campus.
And those specialty teams and any other officers, how were they equipped? Like what type of equipment were they carrying?
I believe most officers carry a sidearm, a handgun, and most
that's not in there, Joey.
Officers in this day and age are equipped with a rifle platform as well.
Okay. When you said that it was possible that round was from an officer clearing his...
Maybe he did. Do you guys remember him saying that in the hearing yesterday, that he said that?
Weapon. What exactly do you mean by that?
Arrival, it was a dynamic and active scene that I believe was originally being treated that there was an active shooter on campus.
Yeah, send me the timestamp.
So there was a large, rapid response of law enforcement who were actively trying to clear, secure, and ensure that the campus was safe, if that answers the question.
The entire campus?
Yes, correct.
Okay. And what types of officers were there clearing the campus?
Originally, there would have been probably local units who would have responded, but subsequently specialty teams would have been deployed to do a more methodical search of the campus and what we would call a clearing of the campus.
And those specialty teams and any other officers, how were they equipped? Like what type of equipment were they carrying?
I believe most officers carry a sidearm, a handgun, and most officers in this day and age are equipped with a rifle platform as well.
Okay.
It's great care. And as my practice, I don't like to rush or make snap decisions, and I want to give this the full analysis that it's due. So thank you again for your patience.
When you said that it was possible that round was from an officer clearing his weapon, what exactly do you mean by that?
Our standard practice in our department is to carry a rifle cruiser ready, we carry our rifles in a situation which is called cruiser ready.
What does that mean?
It means we don't have a round chambered. So if an officer deployed with his rifle, he would chamber a round. Once he had done whatever task it was that he was doing in order to put that weapon back, he would eject the magazine and eject the round. Sometimes in doing so, rounds are dropped or not accounted for.
Okay. Have you personally done that yourself?
Okay. He's just explaining why. Maybe.
The constitutional rights of Mr. Robinson and Ms. Kirk are paramount. Although transparency in judicial proceedings is a fundamental interest, it must be balanced against the constitutional rights of all parties. Having considered the arguments presented by counsel and having reviewed the events that occurred yesterday, the court finds that its order prohibiting the publication or broadcast of Exhibit 16 by the media camera was violated. The court agrees with the defense that this constituted a violation of the court's order. Compliance with court orders is essential in all proceedings and is of particular importance given the nature of these proceedings. With respect to defense's request as a sanction that the court reverse its ruling on defense motion 305, motion to exclude cameras, the request is respectfully denied. The analysis underlying the court's prior ruling remains unchanged, and the court adheres to its reasoning and conclusions. With respects to the defense's alternative request as a sanction to prohibit all cameras and electronic equipment from today's proceedings, thereby preventing the electronic capture of the proceedings for those inside and outside of the courtroom, the request is granted in part and denied in part. Effective immediately, members of the media shall no longer capture or broadcast any exhibits displayed by the parties during today's proceedings. The court finds this sanction to be proportional and appropriate in light of the violation of the court's prior order. The court reserves this sanction as it relates to September 1st. It is not before the court. There has not been a request for electronic media coverage, and the court won't issue a pre-ruling. When it becomes, that request has been filed and all the deadlines which the court has imposed in regards to the MC filing are in place, if motions are filed, the court will entertain motions in brief argument ahead of the September 1st hearing and address it at that time. This is the ruling of the court. Thank you. Turning to the defense, if you wish, you may call your next witness.
I thought that was fair.
We would like the benefit of the record before we start taking evidence today.
Yes, Mr. Grenander, and I'll allow all parties, given the ruling of the court, briefly.
And I'll be brief, Judge. And this is in relation to the continued taking of evidence today. And I'll start my statement, Judge, with something that was very insightful that you said the other day. You mentioned, and I quote, "Sometimes you need to take time to save time," close quote. And so that's my purpose for standing up here this morning. We have spent the better part of
super well. He was just
5 hours, I believe, hearing from witnesses that the defense has called at this preliminary hearing. And no doubt the defense is entitled to call witnesses at a preliminary hearing as allowed by the rules. But I think it's important that the court remind all parties about the purpose of this hearing. This is a probable cause hearing, as Your Honor has repeatedly stated. The defense has invoked the term reliability many times. And the court, frankly, has found the evidence that's been admitted, the testimony. As a gatekeeper, the court has found it reliable. It's been presented. The exhibits have been found reliable. So any questions of additional reliability are really questions of credibility of the witness and weighing of the evidence. And that is not really what this court engages in at the probable cause standard. And so this is all couched in the context of a likely forthcoming standing objection that the state may lodge if the testimony is long and drawn out and exceeds the scope of the preliminary hearing, gets into areas of a 702 hearing, possibly even trial. We will lodge this objection, but I wanted to just simply state the authority, Judge, behind our objection if we do make that. As your court is well aware, the magistrate at this stage of the case must view the evidence in the light most favorable to the prosecution. And that's cited to in a number of Utah cases, to include State v. Schmidt. Schmidt continues, "This means that when reasonable inferences from the evidence cut both for and against the state's case, the magistrate lacks the discretion to choose between them and must leave such a determination to the fact finder at trial." A few other cases I would like to refer the court to. State v. Pledger, which is a Utah 1995 Supreme Court case.
Do you guys mind if I play the Twigs part that Joey's talking about?
The standard bars the magistrate from requiring the prosecution to address or even eliminate alternative inferences that could be drawn from the evidence in favor of the defense. So even assuming the defense scores points today in calling these witnesses, Again, the court cannot really weigh those in favor of the defense. State v. Hester, which is a Utah Court of Appeals case 2000, where there is conflicting evidence, quote, the magistrate may not sift or weigh the evidence, but must leave those tasks to the fact finder at trial. Of course, we're not at trial yet. State v. Virgin, a Utah 2006 Supreme Court case, indicates that a magistrate may only disregard evidence at a preliminary hearing
at some point,
if it is, quote, so contradictory,
I'm gonna play something
inconsistent, or unbelievable.
All right, hold on.
That it is unreasonable to base belief of an element.
your relationship progressed to something more than just roommates, is that right? Mm-hmm. When was that?
I think we started dating 2 or 3 months after he moved in.
Okay.
I remember.
And where did you live at that time?
St. George, in an apartment complex.
And is that apartment the same place you lived?
Yeah, I remember that part. That was in my show. It didn't say gay relationship. It doesn't say that word that you said it said.
And finally, State v. Lopez, Utah 2020.
Come on, Joey. Jesus.
Supreme Court case.
Come on.
Speaking of this probable cause standard at a preliminary hearing, the court said, under this low bar, it may be difficult for the defense to overcome a prima facie showing of probable cause. Even an alleged victim's recantations may sometimes be.
All right, let me keep playing it. See what.
Where did you live at that time?
St. George, in an apartment complex.
And is that
I know, but he doesn't say the word. Like you said, he said that. That's what I was looking for.
On September 10th?
We all knew that.
Yes.
It's not.
When you lived there with Tyler, were you in the same room? Did you live in the same room or different rooms?
Separate rooms.
And at that time, let's say September of 2025, what were you doing with your life? Were you working, school?
Yeah, see, we all knew all this, Joey. You said that he had stuff that wasn't in the one I had. And I'm telling you, he just edited out the redactions, and, you know, that's it. Okay? So I don't know, man. You confused everybody by saying it says gay relationship. And that's something that wasn't worded in it, and we all knew that. So, another wasted time.
I'm not sure what was being requested by Mr.
Yeah, it's no big deal, but you made it sound like it.
During the testimony of the last witness, we had discussion with the state prior to the start. We had a scheduled date for the court to rule on objections. And the purpose of that hearing was so that we wouldn't have to fly witnesses out from the East Coast if there was going to be a standing objection. Prior to that hearing taking place, the state contacted us after they had participated in interviews of Miss Oliver and the other experts, and indicated to us, and we indicated to the court, that there was going to be no standing objection to the testimony of these witnesses. So if he's lodging a standing objection now, I think he's waived it, or he should be stopped from asserting it given the circumstances. I didn't hear that he was asserting that, and I intend to keep this next witness focused on the issue that I think is relevant, which is the state presented DNA reports through a non-expert. They selectively read into the record a portion of those reports which left an extremely misleading impression of the significance of that evidence. So I have the author of the report.
Okay, do you mind if I just want to listen to this thing about the bullet that Wild Bill just said?
Know that the amphitheater area was cordoned off and managed as best it could with the number of people that were there. I was also made aware that there was a rooftop area that had been secured, and also an area off of the side of that building that had been secured by an officer.
And that building was the Low-C building?
Correct.
Wasn't there also a bullet found on another building?
I believe an unfired bullet had been found on another building at some point during my time there on September 10th. Yeah.
Which building was that, sir?
I don't recall.
Was that considered a scene that was worth preserving?
It was not. My recollection is that was accounted for as an ejected cartridge from an officer who had cycled his rifle.
Okay, I thought you said it was an unfired bullet, and now you're saying it was a cartridge?
God, does she not even know what bullet? Are you kidding me? Yeah, he ejected a live round. You know, like that's what you do when you're ejecting it.
And there's a water bottle to your left if you wish. And after you're seated, if you wouldn't mind.
That was a good one there. It seems like later, though, he didn't quite say the same thing.
Mr. Burt.
That's what they assume
Thank you.
happened.
Could you tell us your name, please?
But it doesn't matter.
Oliver, Oliver.
I'll turn up
And
the
Ms.
volume.
Oliver, could you bring that mic a little bit closer? So
Oh, no, I don't have to.
I want to make sure your voice is projected. Thank you. What do you do for a living?
I work for the Bureau of Alcohol, Tobacco, Firearms, and Explosives as a DNA section chief.
And how long have you held that position?
I've been a section chief since January, and I've worked with the ATF for about 9 years. Prior to that, I was a forensic biologist.
And where were you a forensic biologist before you started to work for the ATF?
Prior to the ATF, I worked for Jefferson Parish Sheriff's Office in New Orleans, Louisiana, as a DNA analyst and a DNA quality manager.
Back in September of 2025, what were your duties and responsibilities?
I was a forensic biologist.
And do you recall that around September 11th, you received a request to do some DNA work at the request of the state of Utah?
Yes.
Could we display State's Exhibit 30, which is in evidence?
Mr. Burt, your witness.
Thank you. Could you tell us your name, please?
Caitlin Oliver, Oliver.
And Ms. Oliver, could you bring that mic a little bit closer? So I want to make sure your voice is projected. Thank you. What do you do for a living?
I work for the Bureau of Alcohol, Tobacco, Firearms, and Explosives as a DNA section chief.
Oh, DNA.
And how long have you held that position?
I've been a section chief.
So why is this silent? Like, what's going on here that made it needed to be silent? This is so stupid. Okay, what happened right before that?
A DNA analyst and a DNA quality manager.
Back in September of 2025, we received a request, State's Exhibit 30, which is in evidence.
Okay, it's an exhibit. We don't get to see it, but we're supposed to be able to listen to it. This is just turning into a shit show, man. Just...
Where the state read paragraph D, admitted paragraph F, you state in F, based on this calculation, there is evidentiary support for the inclusion of Tyler Robinson, correct? As a possible contributor.
Correct.
Mr. Burt, I just want to interrupt.
Sure.
I was made aware of a question about the media as it reflects this order. So the question was whether audio could be transmitted, and my ruling covered the video display of any exhibits. And so I just want to make sure that's the understanding of all the parties, that the audio of your portion
Exactly. That's what I said.
That you understand that that's going to be captured by the camera and displayed, but not any exhibits displayed. Is that your understanding?
That is my understanding of the court's ruling, yes.
And to the state?
Yes.
And to the media?
Yes, Your Honor, there might be concern about the actual monitors, the council table, and podium.
Why don't you just turn off the
Well,
monitors in the damn
that's why I
building?
give my notation to begin the morning that the parties are responsible to monitor their monitors.
I guess people inside need to see it. Just don't move your camera.
They're entitled to view it.
Lock your camera
They're
on
responsible to ensure that the monitors, as the camera is picking up the courtroom, it's directed
this is
not to
like
focus
Mickey
on
Mouse
monitors, but
crap.
inevitable capture may occur, and that's why that instruction is given.
Your Honor, Jeff Nye on behalf of the victim representative. We cannot see the court from where we're sitting, so I don't know if there's a way for us to view the monitor.
I don't understand what you're saying.
It's not being published on this
It's not
one.
being published on the monitor to the court's right.
Right, the order of the court based as a sanction is no exhibits will be displayed.
In the courtroom entirety?
As it stands right now, yes, that's correct. Okay, please approach the lectern.
Your Honor, it's just hard for the victim's family to be able to follow the evidence if everyone but the victim's family is able to view the exhibits here in court.
Thank you, I appreciate your concern. This monitor is not on either. So it's only the attorneys. The attorneys have a right to view what exhibits are being displayed, to make their motions, objections, and to see it. It is the court's discretion on what's displayed in the courtroom for publication, and the court issued a sanction given the events of yesterday, and that's the court's ruling.
Your Honor, I just asked the court to consider the victim has the right to be present, obviously, at the hearing. And the presence without being able to see the exhibits, again, it's our position, is not meaningful.
Thank you, I appreciate your concerns. Mr. Burke.
Could you redisplay Exhibit 30, please? And again, while he's doing that, that same conclusion where you include the language, go back to that page, please, 5. Use the term, there is evidentiary support and possible contributor. I want to focus your attention on the words evidentiary support. We've had a prior witness testify that, from the FBI, testified that they use a scale and they characterize the support along the lines of strong. Are you familiar with that type of a scale?
Yes.
Does your agency employ that scale?
We can come to 5 conclusions at our agency, so there can either be exclusion, limited support for exclusion, uninformative, limited support for inclusion, and support for inclusion.
And I take it from what you just said, you don't use these qualifiers strongly. The word strongly include things of that nature.
Yes, we don't use a verbal scale at our laboratory.
Is that a scientific phrase when you talk about instead of saying that there's support for an inclusion, you instead say there is strong support for the conclusion?
So our laboratory doesn't use a verbal scale due to the fact that they add subjective words to the front of this word support. It is our stance that the likelihood ratio statistic the number stands on its own. So we report the likelihood ratio and either support for inclusion or support for exclusion.
Thank you. Would you go to page 8 of the report and highlight the very top of the first 2 sentences? You included this language in your report, correct?
Correct.
And in fact, you included this language in all 3 of your reports, referring to the conclusions conform with the relevant Department of Justice policy on uniform language.
That's correct.
Right. And why do you include that language in all 3 of your reports?
It's standard language for our reports. Our reports adhere to the DOJ Ultra statement.
Okay. And could you go now to Exhibit Oliver 4 for the witness only? Not admitted yet. Are you familiar with this document, the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examination using probabilistic genotyping systems?
Yes, I am.
Right. And would you go to page 4 of that document, please? And the court has heard some prior testimony about this Department of Justice directive. What is ATF's, what is your understanding of what the qualifications and limitations are that are required by this policy of the Department of Justice? What are you not supposed to be saying in connection with the reports that you wrote in this case?
There's a few things that the Ultra document states. First, it states if you use a verbal scale, which we do not, then you need to use the one dictated in the document. This is in an effort to unify the language coming out of DOJ laboratories. It also says that we cannot state that our evidence is infallible, nor can we state that there is a inconclusive result.
Shall not state that it's infallible or have a 0 error rate, correct?
Correct.
It also states, does it not, that you shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample.
Correct.
And are your reports in conformity with that? You're not stating or implying that anything you did here is asserting an absolute identification of someone as the source of any of the evidence that you examined, correct?
Correct. With forensic evidence, it's impossible to state with 100% certainty anything. That's why we report a likelihood ratio, to speak to that uncertainty with a statistic.
All right, and would you go to the next page of that document? This policy requires that you not state or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty. You didn't do that in any of your reports, correct?
Correct.
You're not asserting anything with respect to any reasonable degree of scientific certainty.
Correct.
Correct. Now, when you can take that down. When did you first receive the assignment in this case?
I would have to refer to my case record to know the exact date.
Do you have those in front of you?
I do not.
Okay. Let me pull up Oliver 3 for the witness only. And go to the third page. Does that third page help refresh your memory on when you may have received this case?
Yes, on September 12th, 2025.
Okay. Is that when you first started doing work on the case? Do you receive permission from someone to consume any samples in the case?
Yes, I did.
And could you go to page 15 of those case notes, please? Again, for the witness only. Do you recognize this email?
Yes, I do.
And can you tell me what the email is and what information it conveyed to you in connection with your examination?
Yeah, so it's standard procedure at our laboratory that when we receive a case, we request permission to consume from the agent. We request that they reach out to an attorney if one is assigned. In this case, we will not begin any work on the case until we've received that permission to consume. So this email is us receiving permission to consume the samples and move forward with testing.
Now, does your lab have a policy for preserving samples for independent testing by the defense?
Where possible, we will not consume samples where it's possible.
And that policy is a longstanding one, not only in your lab, but pretty much everywhere in forensic DNA analysis, right?
That's correct.
Goes back to 1996, does it not, when the National NRC recommended a policy that samples be split wherever possible at the front end of the analysis to allow for independent examination.
Where possible, yes, that's correct.
Right, and they did that because it was their conclusion, was it not, that a wrongfully accused person's best insurance against the possibility of being falsely incriminated is the opportunity to have the testing repeated. Such an opportunity should be provided whenever feasible.
Correct.
Okay. Could you now go back to Exhibit 30, page 8? Were certain DNA samples consumed in your analysis?
Yes, they were.
And for the record, are those listed on page 8 of your report?
Yes, they are.
Which samples were entirely consumed in your analysis?
That would be exhibits 1.4, 1.6, 1.9, 1.10, 1.12, 2.1, 3.1, 4.1, and 5.1.
Okay. Then are there a number of samples listed above there in the report where you say the DNA extracts will be retained? And then you list 1.1, 1.2, 1.3, 1.5, 1.7, 1.8, 1.13, 7.1, and 8.1.
Correct.
Does that mean that those are all swab samples, correct?
They were swabs, yes.
All right. Does your report mean that you consume the swabs, but you have some liquid extract remaining as to those samples?
Correct.
Now, are all of the samples, let's talk about the samples in Plaintiff's Exhibit 30. Were all of the samples you looked at there mixed samples?
Could I refer to my tables in my report?
Sure. Go to page 2, please.
And can we go to page 3 and 4?
3 and 4, please.
With the exception of the known samples from the known individual, that was a single source sample, but otherwise the evidence samples were all mixtures.
And in many cases, they were mixtures of sometimes 4 and 5 people, correct?
Correct.
Now, when you look at mixtures, such as the ones in this case, you use terms like major and minor contributor, right?
Correct.
Is that language meant to convey that anything with respect to activity of anybody who might be assigned to that DNA weight? In other words, are you saying the person you label as a major contributor was engaged in any sort of activity? Is there any connection between the use of that language and activity?
None of the testing that I performed could speak to activity or what activity led to the deposition of the DNA.
So nothing in your report, if somebody reads that and says, oh, this one says this person is a major contributor, you're not commenting on anything about the person's activity, correct?
Correct.
And is it true also that there are also several other limitations concerning the language of your report that it's important for courts and people who are reading the report to understand?
I'm sorry, what was the question?
Are there other limitations in addition to the one we just reviewed that it's important to understand about the language you use in your report?
In terms, is there something specific that you're?
Yeah, there is. Could you go to Baker Exhibit 30, page 1, for the witness only? Are you familiar with this publication?
Yes.
This is a publication by the National Institute of Standards and Technology called Forensic DNA Interpretation and Human Factors.
Correct.
This is put together as a guidance document for practitioners on what, to simplify essentially, what to say and what not to say.
I don't know that I would call it a guidance document. NIST is not a regulatory body for DNA testing. It was a report that looked into forensic DNA reporting and specific human factors that could affect our testing. So they may have had recommendations, but as far as them being a regulatory body that's issuing guidelines, I wouldn't state that.
Okay, that's fine. Could you go to 136, please? $136. This is Baker 30. Keep going. There we go, right there. Wait, 135, I'm sorry. And then scroll down to the next page. So they're making recommendations here as to how the report should be worded, correct?
Correct.
Let me ask you whether you agree with some of these limitations, or they call them caveats. They talk about how you describe the number of contributors, and they say the true number of contributors of DNA to an item can never be known. Do you agree with that?
Yes.
Okay. They also say, let me ask one question before I ask this one, which is, do you use something called a reporting cap in all three of your reports?
Yes, so for our likelihood ratio statistics, we cap the statistic at 1 trillion. The actual number could be a lot higher. It could be quintillion, octillion. We chose 1 trillion because it has meaning, I think, to people that can understand what 1 trillion is. An octillion and a quintillion gets a little high at that point, so we cap at 1 trillion.
And they talk here, do they not, about how you convey the idea of a reporting cap, and they say the LR reporting cap was chosen because of the limitation of biostatistical modeling and independence assumptions of STR loci. Do you agree that that's why the cap is chosen?
I believe we chose our cap for the reason I stated.
Do you disagree with that statement in terms of why the cap is chosen?
I'm not familiar with the paper that's referenced there, so I would have to familiarize myself before I said I
Okay.
agreed or disagreed.
Fair enough. And then they also suggest that you alert in your report that profile descriptors cannot be applied to activity level issues. Do you agree with that?
Yes, so this is what you were stating about calling a major contributor. It doesn't speak to the activity that led to the DNA deposition.
Right. DNA profiles may be described as major, minor. However, these descriptors should not be interpreted in the context of a decision regarding the nature or the mechanisms, actions, or timing that led to the deposition of the DNA. You agree with that?
Correct, yes.
All right. And then the other sort of limitation, convey that the DNA results cannot be interpreted as the analyst providing an opinion regarding who the source of the DNA is.
Yes, so this is, once again, we don't make source attribution statements. We will say there's support for inclusion, and then we back up that with a statistic.
So from a scientific standpoint, you couldn't read the paragraph that sets out the likelihood ratio in your report, whatever the number, and then blast a headline in the media, Mr. Robinson's DNA is found on this item. That's a source attribution, is it not?
Correct, yes.
And that would not be scientifically defensible, would it?
Correct.
Okay. Another limitation they talk about on likelihood ratios, on the next page, please, 137. Likelihood ratios cannot speak to the likelihood of a proposition, only to the probability of the results given a pair of propositions. Do you agree with that?
Yes.
Explain that, because that's a little above my pay grade in terms of understanding.
So a likelihood ratio statistic compares the probability of the DNA profile of the evidence given two competing hypotheses or two competing scenarios. Typically, the first is that the person of interest is included, and then the exclusionary hypothesis would be that the person of interest is excluded. So
I'm going to say this right now. This is what I think. I think Tyler Robinson turned off his phone when he, at the top of those stairs, just before sort of entering in the main part of campus, going up and hanging out, and everything he did there, his phone is off. And then he turned his phone back on once he drove over to that mall, thinking that's far enough away. He can turn it back on and start searching and stuff. And, you know, he knew he had to get his gun later, and then he just sort of started taking more risks as he was getting more paranoid about not being able to get his gun later. All right? So I'm going to say that right now. I'm probably the first one to say that. Okay? And I bet you that's a reality. Now, it might not be. Might be he was so stupid. But that almost seems completely moronic to have left it on that whole time as he's moving around campus. All right.
there's a random, unknown, unrelated individual contributing.
And when they're elaborating on that point, they say a likelihood ratio indicates if and to what extent the DNA analysis results support one proposition over another. It is not possible on this basis alone to determine which is the most probable proposition. Do you agree with that?
Yes.
Okay. And then the next limitation they suggest you convey is that convey the DNA statistics cannot imply uniqueness within a population. Do you agree that that's a legitimate limitation?
Yes.
And explain what that means. Does that go back to the issue of source? You can't assign a source to a DNA sample?
Correct.
Okay. It says you should delineate the meaning of a verbal qualifier, but you didn't use one in this case, right?
Correct.
Okay. Now, you mentioned that your testing cannot, and correct me if I'm wrong, I don't mischaracterize it, your testing, none of the testing in any of the three reports can answer the question of how and when DNA got deposited. Is that true?
That is true. DNA can't speak to the activity that led to the deposition of the DNA.
And the report says, with regard to that issue, with the increased sensitivity of DNA techniques and sophisticated software, a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swabbed. Alternatively, a person's DNA may be present when they were not involved in a crime. Do you agree with that?
Yes, once again, I cannot speak to the activity.
Can you explain how it's possible that a DNA profile may be developed even when the
DNA
contributor
transfer,
of that DNA
touch,
never touched
DNA
the item
transfer.
or area that was swabbed?
So it's possible if, say, the pen that you're sitting there using for the week, you, say, hand it off to the judge, and the judge then touches it for a period of time, and then I swab it. It doesn't speak to who handled it last. I could test that. I could get both of your profiles. I wouldn't know which person was the last person to handle that item.
All right. And similarly, if you had a lot of DNA on your hand, we shook hands, I then went to pick up an exhibit, a gun, I touched the trigger of it, your DNA could be on that trigger, right?
It is possible, yes.
Okay, even though you never touched the gun.
Yes.
And that's why, because of those possibilities, you can't make any assessment of how or when DNA got deposited, correct?
Correct.
How long can DNA persist on an item?
DNA is quite stable over time. It can be broken down due to environmental insults, so things like heat and humidity are known to break down DNA over time, but I couldn't give you an exact number.
Were certain of the samples that you tested in this case degraded samples?
There was degradation present in some of the samples.
And what can cause degradation?
Like I said, there's environmental insults, heat, humidity.
Now, the second report that you wrote had to do with a Dremel item that was taken from Mr. Robinson's home.
Correct.
And did you request certain what are called elimination samples in regard to items that were recovered from his home?
Yes.
Tell the court what an elimination sample is as opposed to a sample that relates to what's called a POI, person of interest.
So an elimination sample is a sample taken from a known individual that it may be assumed that they could have come into contact with it. If I were to, say, swab your vehicle, then I would want your DNA sample as an elimination to eliminate you in order to look for any additional DNA that may be there.
And you say they're assumed contributors because depending upon the location, for instance, somebody's house, you would expect if there were multiple people in that house that perhaps everybody in the house could contribute to a certain DNA result.
It's possible.
So you'd want samples from all those folks to see if they contributed to an item that would be associated with a place where they congregated.
Correct.
And I noticed from your case file that you also requested, but I don't think you received, elimination samples from agents who were involved in this case.
Correct.
Why do you request those samples?
The type of testing we perform is quite sensitive, and so it is a standard practice that we request elimination samples from any of the investigators involved in order to potentially eliminate them in case they could have contaminated the evidence.
Okay. Now, in report number 157, if you could bring that up, please. Oliver 157, which has been admitted. The elimination samples that you requested in connection with items seized from Mr. Robinson's apartment were from Amber Robinson, Matthew Robinson, and Lance Twiggs, correct?
Correct.
And that's because you had information that those people were associated with the house.
Correct.
And when you tested or compared, first of all, you determined their DNA types, right?
Correct.
Then you compared their types to what you found on the evidence.
Correct.
And for a certain number of those samples, you found the presence of DNA of your elimination samples, not because they were suspects, but because they were associated with the premises, right?
There was support for inclusion of some of these individuals, yes.
Okay. And if you could scroll down to page 4, which is the table, I just want to review briefly with you. For instance, item number 1.4, which was a swab from the rifle. you used the elimination sample of Mr. Robinson's father, and you found his DNA on that particular swab, correct?
I would say there's support for inclusion of Matthew Robinson on the sample obtained from the swabs of the bolts of the rifle.
I'm glad you pointed that out. That's, again, consistent with your other testimony. You're talking again about support for inclusion as a possible contributor.
Correct. And
Again,
there
not because he's a suspect, but because he's associated with that premise.
correct, and there would have been a likelihood ratio statistic calculated and to go along with that.
Okay. Could you go to the next page? Similarly, with respect to 1.6, you found, again, Matthew Robinson on swap number 1.6, or a profile that indicated he was a possible contributor.
There's support for inclusion of Matthew Robinson.
Okay. And next page, actually go to page 7. You found support for inclusion of Lance Twiggs on swabs of buttons of a Dremel tool, correct?
Correct.
And going back to what we were talking about before, if a person named Lance Twiggs lived in that residence, came into contact with Tyler Robinson, and then touched a button on a Dremel tool, you'd expect Mr. Robinson and Mr. Twiggs's DNA to be on there, right? Or you could.
It's reasonable to assume that anyone living in the household could have contributed to DNA on an object found in that household.
And similarly, you found profiles to suggest support for inclusion of Mr. Twiggs on other areas of the Dremel tool, correct?
Correct.
Okay. Now, the last area I want to ask you about is, you're familiar with something called NGS?
Yes.
What is NGS?
NGS stands for Next Generation Sequencing. It's a DNA technique that sequences your DNA, so it looks at the individual sequence of your DNA.
And is it true that in your field, that whole area of NGS is something that's at the forefront of everybody's attention? For instance, when you go to seminars and you look at the presentations, there's a lot of talk about NGS, right?
That's correct. Yes, it's a newer technique.
And is it being developed by ATF as a technique that's going to be used or has been used?
Not at this time, no.
And is there plans to do that?
Not at this time, no.
Okay. Do you know if other labs have implemented it?
I believe there may be some laboratories in the United States that have it in use, but I wouldn't have direct knowledge of that.
Now, you used a program in this case called STR Mix, correct?
Correct.
And that's sold by a company in New Zealand, that software?
Correct.
Have they developed another program called STR Mix NGS?
I'm not aware of NGS software.
Could you go to 156, Oliver 156? Let me know when you're there. Are you aware that STR, the developers are selling a product called STR Mix NGS?
I was not aware, no.
Okay. Now, sequencing analysis is different than what you did in this case, correct?
Correct.
And how so?
As I said, sequencing is looking at the individual sequence, the individual bases that make up your DNA, as opposed to the testing that I'm performing, which is looking at length variations. So STR testing, which is the testing I perform, looks at areas of the DNA that are known to be highly variable between individuals, and there are areas where the DNA sequence repeats itself over and over again. And depending on who you are as an individual, you may have a different number of repeats present at that location. So the testing we're performing is looking at those length variations. There's a distinction between, say, if you have 10 repeats versus 12 repeats.
But you're not looking within those lengths to see what the sequence of the DNA is.
Correct.
And that's what this new technology is designed to look at.
Correct.
And the reason it's designed to look at that is because it's been found that there are DNA areas that are different in sequence, even though they're the same length. Is that true?
I think the reason for developing NGS software is to add another tool to a forensic biologist tool belt.
Okay. Now, could you go to 154, please, for the witness only? You're familiar with this chart?
Yes.
Okay, this lists all the alleles that you found for all the testing in your 3 analysis, correct?
No, it looks like,
No, you were right, 154. Yeah, this is one, what's the exhibit on this?
This is 154, the second page.
Okay. You're familiar with this chart, right?
I've reviewed the first page of this chart. I have
Sure.
not reviewed the entire
Go to the
thing.
first page. This lists the alleles that you found, correct?
For the known samples, yes.
Okay, now go to the second page. And is it true that for the alleles of interest in this case, one of the alleles of interest is at the D3 location, allele 17?
One of the locations that we look at on the DNA strand is called D3. That's a location, yes.
Right, and in this case, the 17 allele is important because Mr. Robinson had a 17 allele, correct?
Correct.
And some of the evidence had a 17 allele.
Correct.
At that location.
Correct.
So as I understand the way you do this, you look and compare whether those are the same number, basically.
I wouldn't state that's
Yeah,
how
right.
we do our comparison. So it's not just number matching. We're using STRmix,
Oh, that was nice of you.
the StarMix software, in order to
Thanks so much,
perform
Matt.
an analysis of the software that looks at the possibilities of the profile and make comparison to the knowns
Yes,
that way.
share it everywhere.
We aren't using a chart and just doing number matching.
Yeah, and I wasn't suggesting you did, but you're looking at the alleles and measuring the peaks, and it's a fairly sophisticated process, correct?
Correct.
But the bottom line is you're comparing alleles one against another.
Correct.
So if a person is a 1717 and the evidence sample is a 1717, you're looking at that comparison.
Correct.
And again, measuring only length.
Correct.
But it's true, is it not, that researchers have found at that particular the D317 allele, that there are actually 3 different 17s, 17A, 17B, 17C.
Yeah, so there's something known as isoalleles. What that is you may have, in this case, a 17 allele, but the sequence within that 17 allele is different. So 2 people may have a 17, but they may have a different sequence within their 17 allele.
And it's been found that there is a 17A, a 17B, and a 17C, correct?
Objection. Relevance to the probable cause hearing. At this point, I think we've once again gone beyond probable cause, and based on Mr. Grunander's argument, I would invoke his argument here in the case law that he referenced, and I object to this question.
Let me withdraw the question, reframe it, and move beyond it.
All right, so I'll sustain the objection, it will be reframed, and we'll go from there.
It's true, is it not, that at least 1, 2, 3, 5 of the locations of interest in this case, researchers have found that the alleles that you were looking at, these isoalleles, have different sequences but the same length?
Objection. Relevance. The witness has testified she does not do sequencing analysis here, and that's what the question is asking, is about sequencing analysis.
Counsel?
Thank you, Matt.
The
again.
point, though, is that her testing cannot distinguish between these isoalleles, and therefore it goes to the weight of the comparisons.
But if she didn't do that,
Yeah, that's the point, is that she didn't do it, and therefore she's not in a position to draw conclusions.
Mr. McBride?
That proffer is inaccurate, that she's not able to draw conclusions because she did not do NGS or sequencing analysis. She has testified that her lab and the analysis she did here is not sequencing analysis, it's something different. Whether or not she could do sequencing analysis is irrelevant to the analysis that she did do. If Mr. Burt wants to call an expert to say sequencing analysis is better or something like that, that's fine. But this expert does not do sequencing analysis. Therefore, the line of questioning that goes into sequencing analysis is irrelevant to her testimony.
Let me see if I could lay a further foundation.
All right, so I'm going to sustain the objection.
Sure.
And the question may be re-asked if council chooses.
When you do your analysis using length only, do you go by the rule that if any STR locus fails to match when comparing the genotypes between two or more samples, then the comparison of profiles between the question and reference sample is usually declared a non-match, regardless of how many other loci match?
Sir, what's
No,
a
it's not
loci?
quite that simple. What you're speaking of is an exclusion, is that correct?
Yeah, right.
So it's possible for DNA evidence we spoke about, it's possible that DNA evidence be degraded. In a case like that, there may be the potential that some of the profile has what we call dropped out. So it's not present. In that case, we wouldn't expect necessarily to have a inclusion or exclusion at that location because there's no information present there. So it's not quite as simple as is every allele in this chart present in the evidence. There's more to it than that.
If you had a difference in sequence between a known and a question across many loci, would you exclude the person?
It depends.
Again, objection, Your Honor. We're going back into sequencing, which is not the analysis that was done in this case.
Mr. Burt?
Again, Your Honor, if there could be an exclusion based on this and the testing was not done, I think that is relevant.
But as it relates to this witness and her firsthand knowledge, I'm not seeing that tie-in as it relates to her.
All right, let me move on then.
So I'll sustain the objection.
Now, you said that all the samples you looked at in that one report were mixtures, correct?
Correct.
And the number you get in the likelihood ratio depends on how many contributors you estimate, right? The number is going to vary if you say I think it's a mixture of 2 people versus I think it's a mixture of 5 people.
It's not necessarily the number of contributors. The likelihood ratio speaks to the weight of the evidence. And so it's comparing known individuals to the unknown sample. It could be a low number and be a single source sample. It could be a high number and be a 4-person mixture. It's not necessarily directly correlated with the number of contributors.
Let me ask you if you agree with this. This is from the NIST mixture study. A likelihood ratio numeric value is not a measurement of a physical quantity. Do you agree with that?
Correct.
Rather, it is a ratio of probabilities in the opinion of the expert assessing the likelihood ratio and is dependent on the specific propositions used to formulate it and also on the individual making the assessment.
Correct. Yes, I agree.
And does the final likelihood ratio depend on the number of contributors you assume?
No, it does not.
It has no effect whatsoever?
It can have an effect. It's possible. It's possible multiple other factors could contribute to the likelihood ratio.
Is it somehow difficult to figure out how many contributors there are in a sample?
I guess I would say that I use my, my training, education, and experience in order to determine the number of contributors present in a profile.
Well, I noticed throughout your report, you use the phrase, for instance, with regard to the 1.2 sample, the profile consistent with at least five contributors, at least one of which is male. And for 1.1, you say the profile is consistent with at least 4 contributors. I assume by the word at least, you're signaling that it could be more.
Correct.
And as the number of people to a mixture increases, the difficulty in sorting out that mixture increases as well, correct?
Correct.
I noticed in your standard operating procedure, there's some guidance on interpreting 3-person mixtures. Familiar with that, right?
Yes.
And it says, and correct me if I'm wrong, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures, based solely on number of alleles present.
It's possible for them to present, yes.
Well, it doesn't say it's possible. It says, for example, approximately, in all cases, assuming a mixture is a result of the combination of 3 people must be done with caution. For example, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures, based solely on number of alleles present.
You said you're referencing my SOP?
Yes.
Is it possible for me to take a look at it?
Sure.
Your Honor, I'm going to object at this point. The point that defense counsel is getting at is made in the last answer, which is that the difficulty of sorting out mixtures increases as the number of contributors increases. That's all understood, but that has nothing to do with the probable cause determination. Even if it's difficult, the inferences and the evidence is weighed in favor of the state. The court cannot weigh the difficulty in determining this evidence. Is it fair for a trier of fact at a jury? Sure it is. But we're now getting into weight issues that are relevant for a jury, but not for this court.
Well, he's implying this is going to be an extended discussion. I have one question which he wants to look at her manual to make sure it's in there. So, and then I'm done.
All right, I'll allow this question, so I'll
Thank you.
overrule the objection. She may review the material and
So could you bring
question
up
can be rephrased.
one exhibit, Oliver 148? This is your SOP document, correct?
Correct.
And then go to page 83. Did I read that correctly?
Yes.
And so it's true, is it not, that approximately 70% of 4-person mixtures present as 2 or 3-person mixtures?
It's possible.
Thank you. That's all I have.
Thank you. We've been going for a bit, and depending on how much cross, and trying to decide if a break is warranted or if, Mr. McBride, you wish your cross is limited. Again, not trying to say which way you should go, I'm just trying to weigh whether we should take a break.
I will probably be, I will probably be 20 minutes.
All right, let's just keep going, and then at that point, we can take a break. Thank you. Mr. McBride.
Mr. McBride takes the stand. Or should I say, questions the person on the stand about the DNA that the defense team botched.
Good morning.
Morning.
Is your lab accredited?
Yes, it is.
What does that mean?
So our laboratory goes through a voluntary accreditation process where a external third party comes in and audits our laboratory to a set of standards. Specifically, the ATF laboratory is accredited, and specifically the DNA section of the ATF laboratory is accredited to 2 sets of standards. One is an international set of standards called ISO 17025 for testing laboratories, and additionally, a DNA-specific set of standards put forth by the FBI.
Does the accreditation require that the methodologies you use be validated?
Yes.
The methodologies used in this case have been accepted by courts across the country, correct?
Correct.
Does the accreditation require that forensic biologists like yourself satisfy certain qualification standards?
Yes, we're required to perform competency testing prior to participating in casework, and additionally, we participate in twice a year proficiency testing.
And do you satisfy the competency and qualification standards required by accreditation?
Yes.
And at the time you did the testing in this case, did you satisfy those standards?
Yes.
Moving to your opinions, where on the firearm did you find evidentiary support for the inclusion of Tyler Robinson?
There were several locations. I'd have to refer to my report.
Okay, would you look at your report, and this is, it looks like report number, or exhibit number 30. If we can pull that up, just for the witness. Thank you, Kimberly. We had it for a minute here, a minute ago. Okay, if we could go to page number 2, please. Will you just list off the areas of that firearm where there was support for, evidentiary support for inclusion of Tyler Robinson?
The swabs of the stock and grips of rifle, the swabs of the butt plate of rifle, swabs of the trigger and trigger guard of rifle with possible ridge detail / smudging, the swabs of the bolt of the rifle with possible ridge detail / smudging, and the swabs of the forend of the rifle.
We go to page 3.
Swabs of the barrel of the rifle with possible ridge detail / smudging, the swabs of possible ridge detail / smudging on the optical accessory.
And page 4.
The swabs of the protected underside of the receiver of the rifle after disassembly. The swabs of one 30-06 cartridge case. The swabs of one 30-06 cartridge. And the swabs of one 30-06 cartridge.
I want to ask you about a couple of those conclusions. Let's look at page 5.
The judge is just
please.
typing away up there, just typing. Not listening. He already knows what his answer is.
And calculation number 3, exhibit 1.3, do you know where that swab was taken from?
That's not me typing.
I'd have to refer back to page 2.
Can we refer back to page 2, please, Kimberly? Thank you.
1.3 is the swabs of the trigger and trigger guard of the rifle.
All right, going back to page 5. And we've had some talk, some testimony from you and some questions for you about the likelihood ratios. What was your conclusion as to the likelihood ratio that you analyzed in this question, in calculation number 3?
For this exhibit, the DNA profile was at least 1 trillion times more likely if it originated from Tyler Robinson as the major component and 3 unknown unrelated individuals than if it originated from 4 unrelated individuals.
You say at least 1 trillion times more likely. So it could be a much higher number than 1 trillion. Is that accurate?
It's possible.
But there's only 8 billion people on the planet.
Protocols in your laboratory say you cap that at the number 1 trillion. Is that right?
Correct. We would not report a number higher than 1 trillion.
And it looks like you also did a probability statistic as well in paragraph E. Is that right?
Correct. It's another way of stating the likelihood ratio statistic.
And will you state your findings you made here in paragraph E, and that's on page 6?
The probability of an unrelated individual in the population who has not contributed DNA to the sample yielding this level of support is less than 1 in a trillion.
And same question there. The trillion number, it could be far less than that, but you stop your calculations or the statistics at 1 trillion. Is that right?
Correct.
Let us move to page 7 with regard to statistical analysis calculation number 7. Now, do you remember what 1.3 or 1.13 and 2.1 are?
I'd have to refer back to page 3, I believe.
You could jump to page 3. Thank you, Kimberly.
Page 4, sorry.
Page 4.
The 1.13 is the swabs of the protected underside of the receiver of the rifle after disassembly, and 2.1 is the swabs of 1.30-06 cartridge case.
Now, did you do the swabs themselves?
I did not.
And 2.1 is a cartridge case, is that right?
Correct.
And what's the difference between a cartridge case and a cartridge?
The cartridge is unfired, cartridge case has been fired.
Right. Let's jump back to page 7. And what was your conclusion with regard to, well, first of all, why do you group these two together, exhibits 1.13 and 2.1 in your conclusions here?
They were both mixtures of 2 individuals, and they both yielded a likelihood ratio of the same magnitude, so they can be grouped together.
Okay. It's not that they were tested together?
Correct.
It's just that the results were of the same magnitude, so they were reported together. Is that right?
Correct.
All right. What was your conclusion as it relates to both of these as to the likelihood ratio?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major contributor and an unknown unrelated individual than if they originated from 2 unknown unrelated individuals.
And did you make a conclusion here as well about the a probability statistic?
Yes, so the probability of an unrelated individual in the population who has not contributed DNA to these samples yielding this level of support, so meaning yielding this likelihood ratio, is less than 1 in a trillion.
So you're saying there's a chance, said Candace Owens and Baron Coleman.
Nothing else.
1 in a trillion means there's a possibility, you guys. If we could find 1,000 more planet Earths and maybe have the same DNA structure, we could find that one.
Is described as swabs of trigger and trigger guard, right?
Correct.
You didn't do the swabs, but am I correct that you have no way of knowing which part was from the trigger and which part was from the trigger guard?
Correct, so they were swabbed together, so I wouldn't be able to say where the DNA came from.
And that's one of the samples that was degraded, correct?
There were signs of degradation present in that sample, yes.
And you said with regard to that sample, that that was a sample consistent with at least 4 contributors, correct?
Correct.
And did what you term the major profile have the largest amount of degradation in that sample?
There was, yes.
And you can't tell us anything about when the DNA was deposited on the trigger guard or the trigger, correct?
Correct.
You can't tell us anything about whether, when you say it's at least 4, it could be 5, 6, or 7 people with DNA on that trigger or trigger guard, correct?
Correct, which is why we have the major contributor that is suitable for comparison, and the minor contributor is not suitable for comparison due to that complexity.
And again, major, minor just has to do with the levels of DNA you were seeing. It has nothing to do with someone being engaged in activity that is major in relation to the minor contributor.
Yes, so the major contributor is the majority of the DNA contributed to that sample.
Okay. And some of these samples, you have major contributors of more than one person, right?
Correct.
So for sample 1.1, swabs of stock, you have 2 major profiles, and there are at least 4 contributors on that sample, right?
Can I refer to my report?
Sure. It's Exhibit 30. Plaintiff's 30. Right?
You said Exhibit 1.1?
Yes.
Yes, it was a mixture of 4 individuals. There were 2 major contributors.
Okay. And again, with regard to all these samples, no way of knowing when or how the DNA got on those samples, correct?
Correct.
You referenced another statistic in your report, which is the statistic related to paragraph E, I guess.
Correct.
Is it what's called the random match probability statistic? Or is that something else?
It itself is not a random match probability statistic. It is a way to represent the likelihood ratio similar to a random match probability.
But it's still a likelihood ratio computation, right?
Correct. It's based off the likelihood ratio computation.
And it's still subject to all the limitations we've talked about.
Correct.
Can't attribute it to any person. Can't state it's infallible. Can't state there's a 0 error rate. And you can't state that it is a source connected with any one person, correct?
Right. So part of not being able to state source attribution is the reason we report the likelihood ratio statistic. It speaks to the weight of the evidence. And so yes, we can't do a source attribution, and we report that statistic and address that uncertainty that way.
And address the uncertainty along with the other limitations we talked about.
Correct.
Thank you. That's all I have.
Thank you. Anything further for this witness?
No.
All right. May this witness be excused.
Yes.
All right. Thank you, ma'am. You may step down.
Hallelujah.
No, we have no further witnesses.
All right. Returning to prosecution, anything further?
No, Judge, we have no rebuttal evidence to present at this hearing.
Well, thank you, Tall Eagle.
The state
Or
has
Talon
no
Eagle.
rebuttal evidence to present at this hearing. However, before we break, there is the matter that was discussed yesterday with respect to publishing in the courtroom Exhibit 12.1, so that the victim's family can observe that.
Thank you. All right. Do the parties wish to be heard as it relates to this?
Why does that? That's such an easy
briefing,
decision. You just zoom
cautious
in.
ruling
Your Honor, I actually just want to make a quick record. We have advised Mr. Robinson of his right to testify at this hearing, and he is choosing to take our advice and not testify.
Is that correct, Mr. Robinson?
I was hoping they'd say something else.
And I note that he's nodding in the affirmative. Thank you, Ms. Visser. All right. In regards to.
Well, now we don't get to see the nodding in the
issue about
affirmative.
the publication of States
What
Exhibit
a weird looking person. He
12.1,
looks like Data
to
from
the courtroom only,
the old
to
Star Trek.
persons here.
The second,
Any
or, you know.
further input from any of the parties before the court issues its ruling?
Jeff and I, on behalf of the victim, my understanding is you ruled yesterday that you were going to play it, that you did grant our request. So I don't know if we.
Thank you.
That looks like Tyler Robinson, doesn't it?
Judge, I might simply add, given the court's ruling this morning with respect to displaying exhibits, we may want to make a record with the live streaming folks here that it's not going to be published.
Thank you. All right. Nothing further from any of the parties? Okay. Just updating some notes. All right. The court wishes to readdress yesterday's ruling in light of this morning's sanction as it relates to Exhibit 16. The court separately addressed that incident and imposed a sanction on the record. Having considered all applicable public access, fair trial, privacy, and victims' rights interests, the court adheres to its prior ruling. The court finds that temporarily limiting live stream to audio only while Exhibit 12.1 is displayed is necessary to prevent the inadvertent publication of the exhibit from being transmitted.
I thought that was a stupid
to outside
decision.
the courtroom and no broader.
And it's also done by the prosecution, that they didn't add the edits into
and is taking
the raw data. Then it would have been
least restrictive
accepted.
means to accomplish what is being requested. Accordingly, Exhibit 12.1 may be viewed by all persons physically present in the courtroom, including victim representative Ms. Kirk in her capacity as the victim representative.
All he had to do was put the raw
The same in
footage,
court viewing
then
was
the
against
edit
all
after it,
parties
and he would have
and
accepted it.
attendees. And that is the ruling of the court. Let's go ahead and proceed to that, to the stage. So could the camera operator let me know when we're switched to an audio only? We are? Okay.
I was just looking at you.
All right. And as it's switched to audio only, to the
What do you mean by
state,
audio
now, my
only? It's still
understanding
filming
there's
you.
no audio on this surveillance on 12.1. Is that correct? All right. All right. So let's go ahead.
God, I hope he doesn't
play
get
that.
mad. Well, you filmed me when you said audio only.
And I'm going to rule that the
there's
this
not a
also
switch.
applies to the still
Audio.
photographer. It cannot be captured the screen in any way. I noted video recording, but I intend as well as no still capture of any of the monitors during the publication of 12.1. All right. And to the stage, just let me know if you're ready. Let's go ahead and play it now.
He'll accept that right there. So what you're seeing here, guys, is you'll see that Tyler Robinson. That's just the stupidest. God, this is dumb. Yeah, we'll just do it right here. Look, here it is. I have a better version than they've got. Okay, right here you see the Dodge Challenger enter onto campus at 8:22, almost 8:23. All right. Then, believe it or not, it enters into this garage after it drives around at, they have a time of 8:29, so about 6 minutes later. So what we just saw right there is the vehicle drive right in front of this house right here, this direction, came around this corner, drove down this way, and then turned right there onto Campus Drive, drove down and went into this parking garage 6 minutes later. All right, now we're inside of that parking garage. Here it goes.
That's the vehicle.
And then after the vehicle enters into the parking garage, it goes up to the second floor in the parking garage. He doesn't park right there. He goes up to the second floor, or the first floor, which is above the basement where the tunnel is. So he goes up to this floor right here. This is ground level. And then he parks right over on the left, which is on the map. He parks right there, okay? Then, after he parks the car, he gets out of the vehicle, Tyler Robinson does. Name another channel that's doing this right now. None. All right. So then he gets out of the car. I'm going to switch over to this monitor right here. It's better, bigger. And I'll just fast forward. There he is. He starts walking. He got out of the car. He's coming towards the camera. Now, right here, he's right when he leaves the camera here, he exits the building and does stuff on campus. The prosecution moronically didn't do that, so then you see this other video of him walking in the same garage, and you think that's it. So, boom, he exits the garage, which is right there. He comes out this exit right there, and then apparently he goes over to the amphitheater over here, and he talks to a couple Turning Point USA people. And then after he does that, let me just make sure I have everything from there. Yeah, he returns to the garage. So he walks back over to the garage, like an hour later almost. And then he comes into the garage, though, through this entrance right here. That's the entrance he comes in. And we know that because he comes down these stairs on this level, not this level. He comes in, down, and then out, and then he veers off to the right to go back to where his car is. And you'll see that right here in a second. So after he comes back, he's now on the second floor, and he's coming down the stairs. And then earlier, you saw him going out that direction, outside, but he's not doing that now. He's actually going back to his car. So he's on the second floor. He comes down. This is a floor above the tunnel that he's on right now. And then he walks into this area to get back to his car. Now, those are the images I had to flip horizontally. Okay, because they have the wrong, 3 of their clips are flipped horizontally and don't make any sense unless you do that. And that's why when I was doing the show, I was like, this is crazy. What's going on here? Because I know it. I know the area, so it didn't make sense. And then I realized they just have them flipped. So once you flip it, the time stamp and the wording is backwards on the screen. Because the camera itself was filming horizontally, flipped. All right, so it's still playing right now. Here he is. He pulls out, and he's going to do he's reversing how he came in. So he's right here on ground level, and then he goes down a level to the basement. All right, and then he exits the building. Now, right after this, I speculate on where he goes because he's leaving here at 9:33 and 12 seconds. All right, so then I think after that, he drives out, obviously, so here's where he would exit, right there, and then he drives up right there's the exit from the garage, and he would drive up like this, and then he came back around, and then I think he came into this area and parked his car somewhere around here at like 9:40-ish, maybe 9:36 or 7 or 8 or, whatever, right around that time. Because then at 9:57, he walks by this house right here. So literally only 24 minutes after he was in the garage, he's back out walking again with his car parked out here somewhere. It's crazy. And here he is right here. This is 24 minutes later after he left the garage. He's now heading back to campus for what I call his dry run. And look at the time there. It's 9:57. And then you see him walk all the way down. I'll speed it up. So he walks all the way down here. I actually have him go all the way over there, but I just kind of cut it off right there. Right after you see him moving way in the background there, and then boom, he's over here. So I'm going to show you that. From here, he walks around the corner. He's like last seen right over in this area on that footage. Then he walks around like this, back out to 800 South, and then turns here, walks down this direction, and this house right here picks him up walking by. And you'll see it. I mean, it's amazing. Even all these little cracks are the same. See that big square one and everything? So you look that down there, and there's the big square one right there. It's pretty funny. I mean, it's always interesting how that works like that. So here he comes walking by, and then this time he doesn't do the pause because he's just doing a surveillance trip. But you see him veer off, and he gets closer to the grass right over here. See that? Boom. Then from there, he walks over to the... he walks across the grass, over that little bridge, into the parking area, and then right to the tunnel here. And then you'll see him go into the tunnel, and then you'll see a camera on the other end of the tunnel filming him go towards it and then up the stairs. So here we go right now. Here he is going to the tunnel. He goes down the stairs. This is his dry run, and the time is 10:09 and like 39 seconds or so. And now he's walking down the tunnel, picked up on the far camera at the other end. And then he turns, and then he goes up these stairs. And then another camera picks him up going up the stairs. They actually edited that poorly. It should have been right as as he's turning. But here he goes right up the stairs. And then another camera will pick him up turning left, going out of the parking garage, just like he did earlier. That's that same camera. Remember earlier he came down because he was a floor above. All right, and so before it switches over to that, I'll say after he leaves let's cut over this one. Right there, he leaves the parking garage. So he exits right there again. And then he goes on to campus. And he goes to the Chick-fil-A, which is right over again near where the shooting took place. So he goes inside the Chick-fil-A right there. And then he came across, so after going to the Chick-fil-A, he went across Campus Drive. So he literally, goes out of Chick-fil-A, probably walks up over here again, crosses Campus Drive, and goes into the wooded area over here, where he exits without his backpack on anymore. So he left his backpack there. So is he going to test how to get it later? I mean, I don't see a reason why you'd leave the backpack there. And then he returns to campus, no longer having his backpack, but he goes over, he's in this building over here, and he eventually crosses this, and then walks out onto this area to the fence that's right over here. And then he goes to the steps over here, and then he leaves campus. But he doesn't go to the parking garage or anything. They just said he leaves campus prior to 11 o'clock, and they don't say what direction or where he's headed or anything like that. But I think he may have came over here and came backwards through to pick up the backpack, maybe as in practice, to pick up the gun and the blanket later, or the towel. But, you never know if it was because the screwdriver didn't work. That's why he had to leave. He didn't have the screwdriver, not that it didn't work. He didn't have the screwdriver with him, so he wasn't able to take the gun back apart to put in his pants, and maybe that's why he left it there. So that's sort of an issue that still needs to be resolved, right? Then after that, so let's say that is 11...
All right. In that
Oh,
case,
shit.
playing
Man, I was just going to go. 11:05. Then he parks his car at 11:10, but we're going to have to go back.
Transmission may resume. Just let me know when that is.
But see, already, isn't that a better explanation than what the hell they have? Yes, it is.
All right. Thank you. Does either party need the benefit of the record?
The state does not, Judge.
No, Your Honor.
All right. So this preliminary hearing is continued to September 1st at 10 a.m. for an in-person hearing. The court will allocate up to 4 hours total for argument. That's encompassing both parties. Does the defense request that Mr. Robinson be physically present for that hearing?
Yes, Your Honor.
All right, we'll make the recording. Thank you. The court appreciates the professionalism, civility, and respect shown by counsel, the parties, and all persons in attendance throughout these proceedings. As there are no further matters before the court, this proceeding is adjourned.
Oh,
until
there
September
isn't a
1st
closing.
At 10 a.m. Good afternoon to you all.
All right. Well, wow, that was a great, that was like the quickest closing in the world after so much garbage, Guess they're still moving around in there. Okay, let me go back. I'll finish what I was just doing. So I feel like it needed to keep going. Yeah. All right, so after he was in the, let's see, I think he was over at Chick-fil-A, then he exits the campus, and then he must have got his backpack somehow, right? And that's going to be after 11. It's going to be 11 something when he gets the backpack. And then it turns out that, he must have gone back to wherever his car was. Let's say it was right here. Now, right in this area where I had it. And then he drove the vehicle and parked it right there. Right in that little gap there. And it's so fortunate that he parked there and not under the tree. Because we have right here, let me go to the particular shots. Yeah, well, that's it. So right here is a 2013 Dodge Challenger. You can look at the molding on the top. That's the part that just absolutely proves exactly what kind of car this is. The molding on the top, this part right here is not the vehicle. That's just the tree. The end of the vehicle is right there. All right. And then there's another shot of the same thing from a different angle, and it's right there. And now you can tell, see how the tree isn't there anymore. And this is exactly the same vehicle. All right. So it's very incredibly likely that that vehicle parked there is Tyler Robinson's, and the time is 11:26 on that one, and this one it is 11:28, which you can see. Where the hell is that thing? Right there. I mean 11:18. Excuse me. The other one was 11:26, and this is 11:18. At 11:10, the vehicle was not there on another shot. So that means between 11:10 and 11:18, the vehicle was parked there. Isn't that interesting? Because that's exactly the time he would have returned from campus and moved the car there. It's perfect. It's incredible. And so the location of that is right here. Look at that. Same street that you would head down here and walk by that house. So the odds of those things together, and that not being his 2013 Dodge Challenger, are like zero. I mean, it's like it's the odds of that not being his car are so slim that it's almost unbelievable. You know, it's almost like that DNA thing. All right, so then he gets to his car, and by the way, in that footage right there that you're looking at, in this shot there, he's in that car right there. Like he's literally sitting inside of it. And then after he gets prepared, he exits the vehicle probably at like 11:35, walks down like this, walks by here at 11:45, makes this turn, starts walking down this road right here, passes two cameras, 1 and 2. We can see those. So we'll go back to where we were over here. And there he is walking on the street first by the sawtooth wall. Then after doing that, he turns, and now we see him go by this camera. That's the first one, and the second one on that side road that I just told you about. What do you mean we have one more day? It's on September 1st. There's no more day, there's no day next week or anything, is there? I mean, it's September 1st. And there he is walking by a camera, and then he walks by this camera, and then this is that moment that I, again, talk about a lot, is this moment of choice of no return. He had second thoughts, and I believe 100% that he had second thoughts right here. It just so happens to be picked up on camera. That he goes right over here. You can even sort of just see it the way he's moving. Like, I don't know. Shit. Should I do it? Ah, crap. I'm going to do it. Screw it. And there he goes. And then from there, we see him walk right across, again, that same little there's actually just a piece of plywood there. It's not a bridge. Then you walk over, go here into the parking area, and then he walks to the top of the tunnel right there. And he's going to head across going this direction, like that, inside, and then go up some stairs and then eventually come out right there. But here he is at the top of the stairs. So what is he doing on his phone right there? Is he turning it off? I think it's possible he just turned his phone off right there, because now he's ready to go. He knows he's not that stupid. I mean, he's dumb, but I mean, he's obviously not a dumb kid. He just didn't think through it very well. But everybody knows about the cell phone. So let's just see this. He pulls the phone out at 11:53:10. How long did he have that phone out? Oh, wait. Oh, shit. So they skipped it forward there. Interesting. I didn't know that they did that the original time. So he's not just turning it off. I mean, he could have turned it off at the end, but he was checking something. So they flipped it about, it went from 1:53:10 to 1:54. So he was standing there for a minute 25, a minute 26. They skipped it ahead a minute. All right. So he was longer there than I said. Remember I said he was there for 3 or 4 minutes, or maybe 4 minutes, but it was a minute 26. So after the minute 26, he turned it off. I think he may have turned off his phone. That's my opinion. That after he checked on the stuff he checked on, he turned off the phone. And so there he goes. Now he is going. He may have even had second thoughts again right there, because this is really it right here. I mean, you're in. Then he goes through the tunnel. He's right here at 1:55, and he's walking really slow. You see this pace he's moving? I mean, that is probably 2 miles an hour at the best. All right, guys. Well, if you want to help support the channel, for all the coverage that I did on the case, I'd appreciate it. This is our, I guess the last time we're doing this until whenever the hell his rulings are. So if you guys could help support the channel, I'd appreciate it. And then he goes up those stairs right here. These are some of the shots. Like, pretty much like that one was one of the ones they pulled. And then when he gets up here, they used a couple of these. They're just it's a lot blurrier because you're, the video quality filming a screen. Look how slow it is for him to get up these stairs. I mean, it's just brutal. Look at this. One step at a time. He can never move the right leg up. That means it's hindering his entire. That means the gun is going up his back and down his leg. That means his hip can't swing forward. His leg can't move forward, like a thigh can't move forward. Right. Anyways, then he walks up right there and he exits again. And then from there, he walks right down there, here, like this. Down here, and then he cuts up there, goes across, up around here, and then goes in front of the Losi Center building. And then he goes inside the Losi Center building. He comes out. I think he spent like 10 minutes or so over here, standing right in this location, because you can see the place where Kirk is speaking, and you can see that he's on stage. So he waited until he was actually on stage, answering questions, because he does not move after that. And then he goes up the stairs at 12:15. 12:17, hops over the wall, puts together the rifle, inadvertently leaves the screwdriver on the roof, and then at 12:22 runs across over here, lays down, and then shoots Charlie Kirk right down there. Then he gets up after that, runs across over here, over there, and then jumps off the corner onto the ground right there, and then goes across into the wooded area, and then puts the gun into the woods there. And then after that, he somehow makes the gun in the towel in the woods. And after that, he makes his way, change clothes too, makes his way somehow over here by the ROTC building, because he ends up going down this path right here, coming out around, and this is that house that you see him running behind, comes out over here. Then he makes his way I think, back to the vehicle, which is over here. So he made his way back to the vehicle over here. Probably made it back there by 11. I think it was 12:40. And at 12:40, he drove from there to this shopping mall over here, where it shows him pulling in at 12:44:50. Google Maps says he would get there at 12:45, so it's really close. And then when he was parked there, after a minute or so, he looked up Quick Quack Car Wash, and then found out where that was, and then drove there, which is right up here, right there. Then, you know, obviously he went to Dairy Queen at some point, and we don't know where he went for a while after that. And then eventually, at 11 o'clock, it sounds like his automatic text got sent to Twigs that said, look under the keyboard, you know, and it mentioned that he had the opportunity to take out Charlie Kirk and that he is going to take it. And then various text messages were sent, etc. And then he ends up trying to get the gun multiple times, but he wasn't able to do it. Then he parked right here at 12, well, excuse me, before that, just minutes before that, at 12:36 a.m., he's right here, about to turn right, but he notices cop cars, so then he drives straight. And then at 12:40, I think it's 12:47, is that right? Yeah, 12:47, he pulls up right here facing this direction. And then you see Tyler Robinson get out and head this direction, meaning he was going to go try to get his gun down there, but he didn't do it. Then he went back to the car, and then he searched at 1:33 how to well, thanks. Hey, very cool. But a minute ago I said, hey everybody, if you could support the channel for the good work we've done here, and it sounded like this in my head. Listen. Seemed like nobody heard it. So at 1:33, a car parked right there. Then his car was parked there. He pulls out his phone at 1:33 after it was already, you know, he was sitting there and he tried to get out and get and then he says, man, I tried to get my gun, but I'm not going to be able to get it. And that really sucks. All right. Then at 1:33, he searches how to get back to his house. And then at 1:35, he pulls away and starts heading home. And if you look at the time there, it's 1:35 a.m. And that video is all, we actually see all of this stuff. I'm not going to play that video, but there, you know, everything I just explained to you is on this video here. And, you know, there he is right there. He gets out of the car, and there he is at, let's see what time this one is, though. So this is 7:17. So if he left at 1:35, this is 5 hours and, let's see, 1:35, 5 hours and like, I don't know, 40 minutes or so, right? And so maybe he stopped and had something to eat. So anyways, whatever. He's on his way back and he stops at that gas station. Right there. Same clothing, everything. Same shit he was wearing over at the Dairy Queen. All right, cool. Hey, thanks, the Joey. All right. Well, I'll just try it one last time. Hey, if you guys are out there and you want to help support the channel, I'm going to get going here, but it'd be great to have the support. You know, send out some gifted channel memberships, perhaps some super chats. That would be awesome. Thank you. Yeah, I don't really care, Tucson Progressive. All right, you guys. Thank you for being here. I appreciate it. I guess we'll see you guys later then. Be safe out there. Oh yeah, let me say, I did want to say thanks to the people who did help support the channel. We had Jim Lawn, Megan Kelly, we had Timothy Cecil, Wild Bill Wassman, Born to Raise Hogs, Alley Cake, Jim Lawn, Apatheticate, and then Apatheticate gifted 5, then Luciano Braginski, then Alley Cake, then Stevie Lynn, then Alley Cake, then Sally Swift, then Chad Pickett, Stevie Lynn, and then Wisconsin Cat Mom, Stevie Lynn, Carrie Lou, CJ, Wild Bill Wassman, Callie Cat became a member. Then we had Matt gifted a cat eye donation, gave 10 for 4 different people as well. KMTX, KME, Positive Vibes, member for 6 months. Thank you for that. Alley Cake and the Joey 688. All right, thanks everybody.